Listing of him that PA. Listing. No. 1 month.
May please, Your Lordship.
Yes, tell me.
It's regarding item number 45 of today's legal lordship. Kindly may have been taken after come up after vacation, Your Lord. 45 is the order.
Item 45.
Lordship, for the petition.
Adjourn for the day. This is the matter. 29, 20, sorry. 31, 301, 2026.
Lordship.
Okay.
May I please?
Yes.
Figured item number 15 method
15.
15. It was last listed on 21/11/2020. The matter was fixed on 5th of January 26.
Hmm.
Can it be on 5th of January?
Item 15.
Item 5th. This
Fifth-
is the
fifth-
last one.
5th of January.
Fifth.
This 5/1/2026.
May I please, Your Lordship?
Yes.
I beg to mention item number 17, Lordship.
Once.
17. Kindly adjourn for the day, Lordship. If possible, then kindly fix a date after vacation,
After,
Lordship.
after Bihu. After Bihu.
20th on 20th
20,
20.
2/01/2026.
I am for respondent.
You have to respond. They'll inform the petitioner side. Status side. Nice.
Obliged.
Very motor path.
Frame models will continue to the next date of this. Yes. Case diary not received, issue reminder. Interim shall continue. List on. Then we'll take it up. We'll take it up.
Wait, please, my lord.
Yes.
My lord, I beg to mention item number 22, my lord.
23,
22.
22.
22. My lord, it may be kindly adjourned for the day, my lord.
It's there. Diary has come. Not received.
My lord, earlier interim may continue, my
Interim order is there.
Yes, my
The diary is not received. Issue press requisition. The interim order shall continue in the next date of listing. This is the matter after vacation. After vacation.
9 for
9/1.
May I please, Your Lordship?
Petition criminal. Before this.
May I please, Lordship, with regard to item number 49, an IA criminal was filed
Yes.
on the 6th of this December, but it was not tagged together along with
Mhm.
today's matter. So kindly call for the IA. Yes,
Not back.
obliged.
49.
May I please, Your Lordship? I beg to mention item number 13, Lordship. 13.
13.
13. Kindly adjourn for 2 days, Lordship. And 6 after Bihu, Lordship.
For the date 6 of
7th or 8th, Lordship.
after Bihu.
After Bihu.
After 7.
Obliged.
Please, Your Lordship. I beg to mention item number 32. With the report of FSL and report of called for. Their death may
We'll adjourn it.
Yes.
Adjourn. CD is received.
no.
Case diary as well as along with FSL report as called for not yet received. Issue press requisition. Interim is there?
No.
This is the matter on immediately on reopening
Immediately.
after vacation or before? After vacation.
Maybe before
5/1. 5. Is it okay?
May it please, my lords.
Or you want to?
I have another.
saying that-
Item 30, I won.
Okay, 5-1. Yes, next.
Item 34, Lordship. CP was called for. I'm on interim.
This one is your, this diary issue reminder.
Well,
It is
this
that.
case started.
Lordship will take it up. We'll take it up. And dispose it by possible.
May please, my lords. My lords, I pray to mention item number 42. Perhaps a case that has not been received, my lord. On the last occasion on 5/12, my lords has issued a reminder
Oh.
calling for a case diary.
Mhm.
Today also it has not been received, my
It
lord.
has been received.
It's an anticipated bill application, my lord. There's some urgency.
42. Wait for the matter then. Shall we wait for the matter to be taken?
Very well.
No,
It's
it's
received.
received. So we'll wait.
Not written there.
Therefore, likely you have custom.
Oh, very well, my lords. I'm so obliged.
Criminal revision listing against conviction. Against conviction. So, okay, list it after vacation. Fresh matter. Which date? 18.
May it please your lordship. Lordship, item number 15 was mentioned today by the other side, lordship.
You have mentioned.
Which man?
Lordship, a date was fixed on 5th of January. Lordship,
Hmm.
we have objection on that date, lordship.
Yes.
Lordship, some other day other than 5th of
You are,
January.
you,
lordship.
you, okay, 5-1 already fixed.
Lordship, we have some difficulty on 5th of January, lordship.
Well, it has
Yes.
come up today.
Yes, lordship.
Yes, please come up to.
How come? 5-1-26.
Yes.
How come it has come up today? Hmm? Wrongly listed today? I think it's wrongly listed today because it is.
Lordship, the case status, lordship, the front page of the case status, the date was given as today, lordship. When the audit was 5th of January. Lordship, we have some difficulty on 5th of January, lordship. Lordship, the conducting council will be out of station, lordship. Again, we have to take time on that day, lordship.
If we can
Some-
change it,
Please, lordship, some other
Lordship,
day,
we can
lordship.
make a mention on 5th, my lord. Because one of our colleagues from Bombay, he is coming on 5th, my lord. He has requested that as the matter is fixed on 5th, let it be on 5th.
no, because you mentioned without informing the other side.
I have informed my lord.
Lordship, we have
I have
objection,
informed.
lordship, for 5th of January. If required, we'll take up, lordship, we take up today, lordship. Lordship, we don't have any difficulty today. Lordship, from 5th of January. And lordship, the person we have, they'll be, it'll be in the
Okay,
knowledge of the other person, lordship.
We'll
That
take it up and then
Lord,
pass an order.
Lord.
Huh?
deeply.
That will be better.
May I please, your lordship, back to mention item number 14, my lord.
1-4.
14, we have taken concern from the other side.
Mhm.
Can this matter be taken after vacation?
Yes. Fix.
We are having an interim order, man.
Adjourn for the day list on after vacation. 28. Is it okay? 28. 28-1. Interim order shall continue till next date of list.
Deeply objection.
May I please your lordship, I beg to mention urgent listing of criminal petition for warrant recall. Kindly allow for listing on Monday.
And they, okay.
Immediately spoke to PA item number 1.
Lordship, in this matter, both the item 1 and 2 are connected under the same petitioner.
Oh.
So in item 2, the petitioners has been arrested in Golaghat PS case 201-2025. And in item 1, the same petitioner has been arrested in Poliabor PS case 115-2025. And in the alleged section, if you see, the common offense is extortion, which is section 308 clause 4. So Lordship, let the CDB call and kindly a date may be fixed before vacation, Lordship.
The call for the case diary of Poliabor PS case number 115-2025. In this case, he was shown arrested or
Yes, shown arrest.
in
in
the,
Poliabor PS
the
case.
petitioner was shown arrested in this case on 27/11/2020. Petitioners, no?
Yes, Lordship.
Petitioners. List on, if you want it before vacation, we have to fix it on 18. List on 18 1812. Then this also is same, right?
Yes, Lordship, in Golaghat PS.
Here also two petitioners.
Yes, same petitioner, they have been arrested.
Golaghat PS case number 201 of 25, arrested on 14/11/2020, released on 18/12.
Number 3.
They can mix up the just a minute. Just click on tagging. Okay.
Lordship, 483, Lordship. Lordship, FIR in page number 10, Lordship. The allegations are, Lordship, from page number, Lordship, it's from main FIR, Lordship, from page of 14, Lordship, sorry, Lordship, page 14, Lordship. The allegations are, Lordship, 303 subsection 2 and 317 subsection 2, Lordship, theft, Lordship. Lordship, actually, Lordship, petitioner is a Lordship, owner of a scrapyard, Lordship. Lordship, many Lordship economically backward people used to bring things and put it in the scrapyard, Lordship. And police came and thought that those things are Lordship of theft, Lordship, theft, Lordship, but not Lordship. Didn't have anything, Lordship. So 3 years punishment, Lordship, both the section.
Construction site. Right? Anyway, so we'll call for the case diary. Yes.
Before vacation, Lordship, the Azara police station, Lordship.
Call for the case diary of Azara PS case number 174 of 2025. Accused petitioner was arrested on 22/11/2025. This is the matter on 17/12. Chart from everybody.
Much obliged, Lordship.
54.
Wait, please, Your Lordship. Lordship, there are 3 FIRs, Your Lordship. Here we are seeking bail in the 3rd FIR, which concerns us here. Lordship, may kindly come to page 30, Your Lordship. The concerned FIR where we are seeking bail, Your Lordship. The petitioner is seeking.
Page 13.
30.
30.
30. That is Makum PS case number 50, Your Lordship. That was lodged on 6/11/2021. May I read the FIR, Your Lordship? May I read, Your Lordship? I beg to state you that Tinku Tiwari is my son, who is a patient of mental obsession. And on 27/10/2025, one of our neighbor, namely Miraj, deceitfully, Miraj is the petitioner here in, Your Lordship. Miraj deceitfully engaged my son Tinku Tiwari for driving his e-rickshaw. And on the same day, in the afternoon session, near Shankardev Shishu Niketan at Digboy Road, some people caught hold of my son with the e-rickshaw and brutally assaulted my son on his different part of the body, including the vital part, head, that is head, and on an accusation committing offense, my son is being handed over to your police station. Thereafter, on the next day, that is on 28/10. So, Lordship, there was an incident that had occurred on 27th, Your Lordship. What happened, Your Lordship? The petitioner, he is the owner of the e-rickshaw, and he had given his e-rickshaw to the deceased victim. The person, the informant is the mother of that said victim, Your Lordship. He had driven that e-rickshaw, and there was another FIR on that particular day due to an assault of a minor girl, Your Lordship. So that was the entire incident which had initiated the whole process, Your Lordship. And what happened, Your Lordship? When he dropped the minor girl before that Shankardev Shishu Niketan school, Your Lordship, there was a mob lynching that had happened there, Your Lordship. And thereafter, the person, he was the deceased victim, was arrested, and he was taken to jail, Your Lordship. And during custody, Your Lordship, he had died, Your Lordship. And thereafter, initially there was a FIR under POCSO, and thereafter one UD case was also registered, and thereafter this has come, Your Lordship. And this was only on 6/11/2025, Your Lordship. If I may continue reading, Your Lordship. Thereafter, on the next day, that is on 28/10, my son was forwarded to judicial custody in reference to Makum PS case number 48 of 2025. In the jail Hajat, the health condition of my son was deteriorated, but the jail authority did not provide any treatment to my
I've seen.
son.
I've gone through this.
And finally,
He died on 4/11.
4/11 on 3/11
Expired on.
during the late nights, Your Lordship.
Yes.
His
Thereafter, this on 6th, this was lodged.
Yes, Your Lordship. Lordship, only allegation where my name appears is that our neighbor, namely Miraj, deceitfully engaged my son. Your Lordship, I am a owner of the e-rickshaw, Your Lordship. And generally the practice is that we give it out to somebody and then certain remuneration is charged, Your Lordship. There is nothing as deceitful or anything. And Lordship, this is highly improbable, Your Lordship. Where the mob lynching had occurred, it is in a different location also, Your Lordship. Only because I am the owner of the e-rickshaw, Your Lordship, my name has been mentioned here, Your Lordship, along with another person where he was alleged to have tied the ropes and all sort of things during the mob lynching, Your Lordship. Lordship, here I'm praying for interim relief, Your Lordship. As on date, Your Lordship, 32 days behind bars, Your Lordship. I have been arrested on 10/11, Your Lordship.
I would like to point out, Your Lordship, one thing, my lord. In the first FIR, in the first second column, more Miraj deceitfully engaged my son, and otherwise, my lord, what the present, my lord, his son, my lord, what is the offense actually he has committed for which he was brutally
Lynched,
assaulted, and ultimately, my lord, he was, my lord, expired, my lord. And what is the actual offense, my lord, and for which he was, my lord, handed over? So that is not come out from this, my lord.
Not come
The
out.
Lordship may kindly
So
peruse the
only
first
this-
FIR then, Your Lordship.
And why he was
just for a
assaulted by the
moment,
public, my lord.
Makum PS. No, let us get it on Tuesday or Wednesday. But it will not come. No?
Yes.
18th.
Lordship, another
Yes.
co-accused, the bail is been fixed on 8/12, Your Lordship.
8/12. 8/12 is gone.
18.
Sorry,
18/12.
So,
Okay.
Number to put.
Same PS.
same PS, Your Lord.
No problem. Same PS. We'll call for this. Then let us. It will be better to see the case diary in this. The facts are. You are right.
Yes.
Slightly.
The
Call for
incident
the
was all.
Case diary of Makum PS case number 50 of 2025. The present accused was arrested on 10/11/2025. The released the matter on 18/12/2025 along with BA 3949 of 2025. Okay. Along with this, it will be listed.
Yes.
Same effect.
Deeply.
You want this back?
No, Your Lordship, that may be kept on.
55.
May it please your lordship. 439 applications, my lord, all offences, my lord, punishable by 7 years and less, my lord. FIR, my lord, at page 8, translated copy, my lord. The allegation with regard to the petitioner is concerned, my lord, is that he's been an employee of Axis Bank. He have, my lord, transferred an amount of rupees 5,50,000 of the informant, my lord, to the account of his mother, my lord. And he was arrested on 31/10, my lord, 42 days behind the bar. May I take your lordship to page 16, my lord? Page 16, my lord, happens to be this. This is by the informant herself, my lord. And she has given to the police station, my lord, with regard to this, that a money of 5,50,000 was as a loan which was given, but she got back the money and she did not want to pursue this FIR. And at page 17, my lord, is the money receipt also. And at page 18, my lord, is been the agreement, notary agreement, it appears to be.
What happened actually? The facts that
My lord,
allegation
facts
was
is
that-
this, my lord. Maybe, my lord, the petitioner has done some mischief, my lord. And for that purpose, my lord, he was arrested 42 days behind the bar.
that husband's pension used to deposit in Apportion Bank.
Yes.
3 days ago, I came to know that.
And the informant got back her money.
One of the employee transferred that to his mother's account.
Mother's account, my lord. So, my lord will kindly see the documents at page 16 to 18, my lord. All money has been returned, my lord. All money has been returned, my lord. And my lord, 16, my lord, it's an acknowledgement with regard to that, wherein she has stated that she has given as a loan. This is the informant to the officer in charge. Carry the instant case, my lord. And at page 17, my lord, is the money receipt that she got the money back, my lord. Even before arrest also, she got it on 30/10/2025, page 17, my lord. Before arrest, 31/10, he was arrested. 30/10, she got 50,000 and rest of the amount on 15/11, 5,50,000. And the notary agreement at page 18, my lord, will kindly see. Here, my lord, with regard to this, my lord, according to her, it's a confusion and for which she lost the affair. And for that purpose, my lord, she received back all the money also, my lord. And she prays before this she prays for filing final report. Whatever it is on the merit, my lord, I am not on that. 42 days behind the bar, money has been got back, my lord. If at all surcited, my lord, he'll face the trial if any wrongdoing has been done, my lord. So, in that view of the matter, my lord,
When can you get the case diary?
Any short date one.
He's a bank employee, that's
Bank
the
employee.
problematic.
no, my lord, what I am on is this, my lord. He's been behind the bar for 42 days. Now he has lost his job, my lord. The affair has been lost, and thereafter, my lord, all the money has been returned. It is the informant who has stated, my lord, so and so, so and so, so and so, resident of so and so, so and so in the district of Kamal is which is returned by his mother, so and so, so and so. So all money has been returned. So investigation, my lord, will take its own course, my lord. So my case is very simple, my lord. That why he should be behind the bar for further investigation of this case, my lord.
Anyway, I think I'll call for the case diary Tuesday.
On
Tuesday.
On Tuesday.
For the case diary. That is the only aspect.
Yes.
Further, maybe
He has committed some wrong, my lord.
No.
Definitely, my lord.
I mean, we'll not condemn him also because he's the allegation.
Yes.
But anyway, quick date. We call for the Hatigaon. Hatigaon should come.
My lord.
Today is the last date. Hatigaon, call for the case diary of Hatigaon PS case number so and so. Short order below. Petitioner is stated to have been arrested on 31/10/2025. Release the matter on 16. 16/12.
Obliged.
It's possible. On that day, if possible, you can get the original agreement on that day.
It is there with me. Right now it is
Keep
there.
it on that day.
Yes, yes.
May I please lordship? Initiative election lordship, non-affair case lordship. My friend is supposed to take
Yes,
instruction.
my lord, as per my instruction, case registered against the petitioner, my lord. All women police case number 86/25. Well, at this stage, might be a case diary maybe.
This
In the meantime, I may be
allegation,
My allegation, my lord,
Under
regarding
section?
that aspect, my lord, there is no
nothing.
only one case registered.
Right.
Regarding
Under which section?
section also not mentioned, my lord, only case number.
So, my lord, no course of action may be taken up.
Your lordship may kindly call for the case diary. I'll produce it on 16.
16.
16.
But till then, my lord,
No,
I
my
may
lord.
protect the lordship.
Till
Because, my
I
lord,
don't know anything. What is the allegation? What section? Do not know anything actually. It will be,
well, no
if
course of
it's not
action.
registered, then sometimes it is given. But it may be something related to.
I may be allowed to appear lordship before the police lordship.
No, let us see this. What is it about? What is the allegation? What is the section? Otherwise,
There was a love affair between the petitioner and my lord informant lordship. Both are major lordship. They have to break up and she went to police station lordship.
Monday is not possible.
Monday I will try.
Should I fix it on
Otherwise,
Monday?
Tuesday would be convenient. Tuesday,
No, really.
definitely I can place.
Upon instruction, the learned additional page, Mr. Bhattakur submits that the case has been registered against the petitioner in the all women police station. But further details regarding the allegations for penal provisions are not available at this stage. Therefore, call for the case diary of
All women PS case number
Uh,
86/20.
call for the case diary of all women PS case number 86 of 2000.
86 oblique.
Actually, from from their point of view also it will be fair.
Yes,
When we call for this kind of report, now if case is registered, they
Yes,
must
Lord.
give the sections also.
yes, my lord.
So that
Yes, if it is,
because he has a right to make the prayer, right?
yes,
For
Lord.
protection. But I'm just blank. Just wait for today's 16th. 16th.
My lord. In this case, my lord, on the last year, on March, there was an FIR, my lord. Now, its charge sheet is filed, my lord, someone is issued. My apprehension that, my lord, since the case was registered under non-believable section, my lord. So if I appear, my lord, I may be put in custody. So I need protection, my lord. I will face trial, I will appear.
What is the allegation?
Allegation, my lord, kindly see the charge sheet, my lord, page 28.
It's charge sheeted already.
Charge sheet, my lord. Someone is issued, my lord. Page 29 is the
Someone
sum.
is it. Charge sheeted under, you must
Charge
have
sheet under
next charge sheet.
148, 149, 447, 323, 326, 307.
Absconded.
Absconded.
Conversion.
I don't full face trial, my lord, on each and every date.
Scan copy maybe.
My lord, if
307 is there, no?
Yeah.
Charge sheeted.
so, my lord, if your lordship next date on 26 to 2024, 2025, 2026, my lord. So if your lordship transportation, my lord, I will appear on that date, my lord.
What is the next date?
Next date on 26 to 2026.
Sometime back. Quite some time. Warrant is issued. No.
Not issued, my lord. Someone issued.
It's okay. I think we can examine and
Yes,
dispose it of.
scan copy.
If warrant is issued, then probably, something might have to be done. So, when should we fix it?
My lord, immediate February 2 তারিখে on 9 মানে January after case is already my next date up in February.
Immediately after, first week only. You'll be.
Yes, on 9th,
5, 6, 7, 8, just one of these days you will.
8th of January, 8/1.
Keep it on 7. Last
Yes,
day before.
7.
7 is when. Yes. Scan copy. Call for the scan copy of the case record within bracket comprising charge sheet, case diary, from the, it is in from which court? From the court of the learned additional CJM, Sri Bhumi, of PRC number 2059 of 2024, GR 2059 of 24, GR number 623 of 24, arising out of Bodorpur PS case number 89 of 24. The case has been charge sheeted against the petitioner under section 147, 147, 148, 149, 447, 323, 326, 307 IPC, indicating him as an abscond. List the matter on 7/1, 2020.
Number 6.
The anticipatory bail application, Lord. At page 15 is the FIR. Lordship, I kindly note the date of registering the FIR is at 9/11 and the incident took place on 5/11. May I read the FIR? I'd like to inform you that on 5/11, 2025 at about 8:30 p.m., after I returned from home and reached home, I saw that the above accused person naked along with my wife on the bed and caught red-handed and called the local people and handed over the accused to the Morikolong police. Regarding this incident, I had a conversation with my wife and I came to know that the said accused person had committed physical intercourse with my wife by blackmailing her. Many years ago, my wife had a love affair with the accused and some of the nude pictures of my wife were in the hand of the accused. The accused person was blackmailing my wife to do physical intercourse by showing these nude pictures. Moreover, the accused person threatened my wife that he would make those pictures viral on social media if she does not keep the physical relation with him. Further, the accused suggested his wife to kill him by giving poison. No other alternative to come. Now, Lordship, may kindly turn to page 28. Page 28 is the FIR which was being attempted by the informant on that particular day. that is on 5/11/2025. The content is different. The GD entry was being made, but that was not being registered. With due respect, I would like to inform you that the accused number 1 is the son of my aunt, and because of which he came to my house. Accused number 2 is my wife and the mother of 3 children. That yesterday I came home at night about 8 p.m. Then I went to the kitchen at the back. I saw both were naked and were involved in the bad activities. My wife hit me in my head with a bamboo stick, but I bent and the blow hit in my back. The accused number 1 gave several blows to me and tangled my neck. But when I made hue and cry, the neighbors came and saved my life. After receiving the information, the police came and took away the accused number 1 to the police station. So both were taken to the police station. It was not being registered because it was not the informant, but the petitioner was being badly hurt. And in regards to this, the mother of the petitioner filed an FIR. Your Lordship will find at page 21.
They understood actually. This I have understood.
Yes.
This incident, he
Yes.
a compromising position. Then that this was there, and
The real fact lies in the page 21, Lordship. What had happened? Actually, he was being called by the informant to take away the sum that was being due to him, 1,50,000, and he was repeatedly being called to come to their house. And it was after the FIR was made on 8 this FIR was made on 8/11, and thereafter this cross FIR has been lodged on 9/11 by the informant. Because this has been registered against the accused person as the informant, under section extortion has been registered against this case. This has been registered under section 117(2), 3082 and 35.
just
So
hold on.
thereafter, cross
Give me-
FIR has
just give
been
me 2
lodged on.
minutes. Just give me 2 minutes. I'll go through this once again. 811 Azahar. According to you, this was filed before 811. 811.
Yes.
By
8/11
by
has-
Ayasha Khatun,
Yes, the mother of the petitioner.
mother of the petition.
Yes.
11. Just I'll 811.
But incident
Then I'll
occurred,
come to you.
incident occurred on 5/11. Your Lordship.
With respect. 511. Easy facts. Can you throw some light?
The incident
Can you
occurred on
throw some light?
incident occurred on 5/11. Thereafter, mother of the accused has lodged an FIR on 8/11. That can also be said to be an afterthought, my lord, only to save the skin of his son, my lord. Because actual incident is the present case, my lord. FIR registered on 9/11, incident 5/11. Incident is 5/11, and the mother of the my lord petitioner has lodged the FIR on 8/11. So that can also be said to be an afterthought, only to save his son, my lord.
And this is filed on
9/11. And
no, no. Thing is that more than this, whatever it is, relationship issue or illicit, but this FIR, the greater problem in this FIR I find is about this modus operandi, which we find in many cases now.
Yes.
Hiring photographs.
Yes.
So at this stage, I think we should just call for a case that fix it on which Nagaon. So
Yes.
16th,
Lordship, my
17th.
kindly interim may be granted
Interim,
because I have also
facts are-
at page number 10, I have also given the GDA number also that has been they have attempted on 5/11. The GD number at page 11, Morikolong POP, GD
filing
number.
a false case is a
Yes.
uh,
That was
severe
not being-
offense in itself. But the thing is that no, prima facie, this FIR These allegations of, that, blackmailing her, all this.
Now the fifth, on fifth that has been
This
registered.
sentence I have not understood. Accused suggested his wife to kill him by giving him poison. This I have not understood. It does not fall into context. Anyway,
On fifth also, it has been said that the wife has beaten him. If the wife has beaten him on his back, then why she will be giving this kind of statement or registering this?
Nogam will
On 17, on 17 or 18.
already we have fixed a lot of matters actually,
Yes.
but we'll have to continue fixing matters.
Yes.
There's no other option. So will it come on 60 or
Yes,
difficult?
16, my lord, I can try. but
No go.
17 or
17 will be realistic.
Yes, 17 or 18.
Call for the case diary of Nogam PS case number 8898 of 2025. So and so. Just hold on. I'll just have a look.
At least the interim may be granted till that.
Let it be. Fix it on 16, Tony. 16. Huh? Right. 16.
Oblige.
Maybe dollars. So, my lord, FIR at page 9, my lord. And we have also cross FIR against them, my lord. It is a fabricated case, my lord, just to harass.
Can copy of this year poll question there.
No. If I make fair with my lord the FIR, my lord. FIR at page 9, my lord.
Yes.
Submission is that on 4/8/2025 at about 8 in the morning, the accused persons in a group came to occupy our land, land dispute, with dao, lati, etc. Because of absence of the male members of our house, I protested. Then the accused persons assaulted me and pushed me into the ground. This is the allegation. They also dragged me. Having heard my hue and cry, nearby people assembled there, and then the accused fled away. On investigation, the evidence will come out. This FIR has been filed on 7/8/2025, my lord. But prior to that, my lord, your lordship may kindly see page number 13. We have filed a case against one Najimuddin. And the present informant Husna Begum is the aunt of that Najimuddin. And against Najimuddin, we have filed a serious case, my lord, that he has sexually assaulted my lord, minor daughter of the petition number 2, my lord. And the case has been registered under POXO Act, my lord. Well, page number 13, my lord. This is our FIR. The submission is that the accused person is our neighbor. He is very clever and notorious. He works at the Nilambazar Circle Office on private basis. Today at around 7:30 am, when my husband sent my daughter, namely so-and-so, aged 13 years, to the house of the accused person with some land documents belonging to us for the purpose of mutation work. The accused person called my elder daughter to his room and asked the younger one to wait at the courtyard. With evil motive, the accused person took my minor daughter to his bedroom and by grabbing her mouth and clothes, disrobed her and tried to commit rape upon her. Then my daughter started even cry, hearing which my younger daughter went to the room and saw the accused person is about to commit rape upon her elder sister. Then the accused left my elder brother and asked the younger daughter not to tell the incident to anyone. He also promised to give rupees 500 to her and then ran away. Then my younger daughter covered her with a bed sheet and put her clothes and took her to our house and narrated the incident to me. When I promised the same to my husband, when I informed the same to my husband went to the house of the accused to ask him about the incident. The accused person attempted to kill him with the. Then my husband ran away to the house. So this FIR was filed, my lord, on 4/8/2025. And after, my lord, 3 days, the aunt of this accused person, Najimuddin, my lord, filed this FIR, my lord.
How are they linked? Nazim, who's Husna Begum?
My lord, here in our present case, my lord, Husna Begum.
Husna Begum, informant?
Is the informant, and she is the aunt of that Najimuddin. And
Where is it written that she is an aunt?
My lord,
Have you stated? You must have stated then.
yes, my lord. Yes, my lord. Your lordship can say, I have stated, my lord.
Just we have to see the linkage, right?
My lord, I have stated. Your lordship may kindly see, my lord, page number 3, my lord. Kindly see, my lord. The petitioner back to state that the FIR does not constitute any serious cognizable offence. Furthermore, it has been filed by one Husna Begum, who is aunt of one Najimuddin, against whom the wife of the petitioner number 2 has filed an FIR alleging sexual assault of her minor daughter Shahira Begum. The said FIR filed dated 4/8/2025 was registered being Korimganj PS case number so under section 76 BNS and under section 18 of the POCSO Act. Subsequently, the instant FIR against the petitioners has been filed by Najimuddin through his aunt, namely Husna Begum, as counterblast to defend himself and use it as a shield, my lord. Actually, my lord,
Five of the petitioners are here. Right?
my lord, 1 to 4 are, my lord, brothers to each other, and fifth is their near relative, my lord. So, my lord, CD may kindly be called for, and in the meantime, we may kindly be protected, my lord.
Yes, after my lord, already since incident of 2012, now my lord, there are lots of allegations my lord, against the present accused person, my lord. এই তো 2000 লিখে নিলে আপনি।
কিন্তু আপনি আৰু বেলেগ কিবা কেছ লৈ আহিছে
এইটো আসল আপোনাৰ এফআইআৰ এখন নহয় জানো কেছ 9 এইটো এফআইআৰ আপোনাৰ
এইটো বঙাইগাঁও হয় আপোনাৰ বেলেগ ফাইল লৈ আহিছে
Korimganj PS.
কৰিমগঞ্জ কেছ ফাইল অফ বঙাইগাঁও
370 and earlier against by them is 363.
Yes, this one.
Heard Mr. Talukar and learned additional Mr. P. Potter. Invoking 482 BNSS, the 5 petitioners herein, accused petitioners herein, are seeking anticipatory bail in connection with Korimganj PS case number 370 of 2025 under section so and so. This case was registered based on FIR dated, Azahar dated 7/8/2025, lodged by one Husna Begum, naming 6 accused persons, including the present petitioners, with the allegation that on 4/8/25 in the morning, they came in a group armed with dao, lathi, etc., and assaulted her, and upon her hue and cry, neighboring people came, whereupon the accused persons fled it. The learned counsel has drawn my attention to an FIR dated 4/8/2025 lodged by Rabia Begum, wife of
Petition number 2.
Krishna number 2 Abdul Rahim against Nazimuddin, with the allegation that he had tried to commit sexual assault / rape upon her elder daughter on the said date, that is 4/8/2025. It is submitted that the informant Husna Begum in the case lodged against the petitioners is the aunt of
Najimuddin,
the said accused Nazimuddin, and this has been stated by the petitioners in para 4, right? Para 3 of the bail petition. One case diary will do.
Yes,
One call for the case diary from the concerned police station. I've considered the prayer of the learned counsel for interim protection. In the meantime, upon perusing the materials, the possibility of the present FIR being a counterblast cannot be ruled out altogether. Therefore, it is directed that in the interim, in the event of their arrest in connection with this case, they shall be allowed to go on bail of 20,000 each, surety of the line, to the satisfaction of the arresting authority, and subject to the condition that we cooperate with investigation, appear before the IO for recording these acts. You can list the matter after vacation.
Yes, after vacation.
Suggest a date.
On my lord 19/1.
highly applied.
19 months.
May I please tell Lordship? In this case, my lord, the allegation is that the 2 municipality employee misappropriated amount of rupees 18,000, and I am one of them, my lord. Not so. My lord, kindly see para 3, my lord, for a moment.
Para 3.
Para 3, 4, and 5, my lord. May I read? May I read, my that the petitioner begs to state that the allegations leveled against the petitioner is not applicable in case of the petitioner. He was appointed as a junior assistant of Sribur municipality. Since his appointment, he had been discharging his duty with the satisfaction of all concerned. He was never complained for any of his official duty performed by him. He, being a junior assistant, has not been entrusted to official duty of tax collection. His job is to do clerical tasks. Whatever receipt deposited in the office is to be entered in the official record. The petitioner, being as a junior assistant, had made an entry of the receipt into this official record. It is not the duty of the petitioner to inquire about the authenticity of the receipt for the documents. As such, the allegation of the misappropriation not lie upon the petitioner. Now, my lord, second parameter, that the petitioner begs to state that the present chairman had ordered the petitioner, along with the other co-accused, to do some misdeed and illegal task which gained the complainant.
Are you reading from para 2?
Para 4 now, my lord.
The para 4.
Para 3 I have read.
So the present, okay. And present chairman had ordered the petitioner.
Ordered the petitioner along with some other co-accused to do some misdeed, illegal task which gained the complainant. The petitioner came across that the said task is grossly and apparently illegal, and as such the petitioner refused to do such work in favor of the complainant, for which the petitioner become eyeball of the complainant. The complainant number 1 has interest to provide job to his one of the relative in the municipality, for which he has a plan to terminate the petitioner. The said plan is come to on observing the act of conduct of the complainants, is just filing the FIR that without giving an opportunity of hearing, immediately suspend the petitioner by issuing suspension letter dated 4/12/2025. Now, my lord, para 5, my lord, that the petitioner begs to state that the amount of misappropriation is 18,836, and the said amount is misappropriated by the two accused persons. If the said amount is distributed among the accused person equally, then the misappropriated amount of rupees 9,480 rupees only lie upon me. So this is the real case, my lord. However, my lord, the clerk had collected the tax, my lord. Their allegation is that the receipt is sometimes false receipt. This is not our duty, my lord. So my humble submission, my lord, I will cooperate.
According to you, the suspension order is malicious.
Malicious, my lord.
No, but it is a proper, they have referred to a case, they have referred to all these, it is.
My lord, kindly see page 18, suspension letter, I have annexed.
Yes, I've seen, that is what I'm saying. Anyway, so what is the FIR?
FIR, my lord, kindly see page 13.
You have not taken me to the FIR.
Page 13, my lord.
I'll go through it myself.
Yes.
Hold on. No, they've given full receipts, all this, only case diary at this.
Yes.
My lord, my humble submission, my lord, I'm a municipality employee, my lord. Will cooperate the investigation in each and every call. my lord.
They have allegations are, they've given all the details. How they, fake receipt was issued for a higher amount than the genuine amount, and it was misappropriated. All the details have been given, prima facie.
My lord, my humble submission, what is my humble submission, my lord? I will cooperate the investigation, my lord. I will appear before the cooperative investigation authority, my lord. So, my lord, my lord, an opportunity provided to appear before the investigation authority, my lord. So, till then, my lord, I will appear before the investigation, my lord.
Call for the case diary of Sri Bhumi PS case number 500 of 2025, and that's so and so section. The case arose out of an FIR dated so and so, lost by three officials of the Sri Bhumi Municipal Board, including the chairman, giving details about misappropriation of property tax by providing false receipts for inflated inflated amounts. Petitioner has also been put under suspension by the order dated 4/12/2025. The learned petitioner counsel submits that he has been maliciously targeted and that the allegations are false and prays for interim bail. However, at this stage, I deem I'm inclined only to call for the case there. So this is the matter.
On my lord,
When can you give it?
1912.
19.
Still then, my lord,
So, the prayer for interim bail, which I have to legal. Kindly, so the allegations are like.
May it please your lordship. FIR, your lordship will find page 10. It's there. Allegation is that accused persons entered his shop and by breaking the lock and looted and caused damage of 3 to 4 lakhs. Lordship. That is the allegation. Page 10. And schedule of the land, your lordship will find page 11. They have mentioned the schedule of the land at page 11.
Just a minute. FIR is at 10, right?
Page 10.
Would you like to read it?
Lordship,
Yeah, I can
lordship.
read it.
With due respect, I beg to inform you that yesterday night at about 1 a.m., the above named accused person had stolen some furniture by breaking the lock of my shop and completely destroyed my shop, which is located at east side of Fakir Bazar, or at an approximate financial loss of rupees 3-4 lakhs has been caused to me. Therefore, I request your honor to kindly take necessary action against the above named accused person. So now lordship may kindly say page 14. He has given the description of the land, that patta number 14, dag number 318.
Page 14.
11, lordship, page 11. Patta number 14, dag number,
Schedule land.
yes.
Furniture.
Now-
shop.
Now
Stealing from furniture shop, right?
Furniture shop situated in this land.
For this land.
This land belongs to me. There is no shop at all, lordship. Lordship, I am having all the documents. Lordship, may I kindly see that page
The allegations
45
are false according to you.
Lordship, page 44, official document I am placing, lordship.
The land belongs to you.
Yes, there is no shop. He wanted to occupy that, therefore he lost the present case, lordship. That page 44, that lordship will find that circle officer certificate certifying that
Just
that land in my possession.
certified there. Okay, let us just see what is
Hmm.
1 Katha 3 7. What is this? It's a different terminology used. That's right.
Lord,
1 Katha 3 CH. What is this? CH 7G.
lordship. That is different in Chatak and
Yeah, it is that
Chatak.
term is used.
yes, they use different.
Land tag number 318 Pathanama been found under possession of Hussein Ahmed.
Then your lordship will get
wrong.
then Panchayat certificate. They have got page 46 and 47 for electricity connection because they are going to construct one house in that land.
It in the name of PC land to certificate.
And in this regard, lordship, they also filed lordship one petition before the officer in charge. Page 40, your lordship will get, and that was treated as lordship under 107 lordship CRPC. It was forwarded to magistrate lordship because he said lordship that we wanted to construct our house and the informant side is obstructing that. And one important fact, lordship may kindly see page 25. Page 25. This is the vernacular, lordship. That Niazur Rahman is the informant. Your lordship will get page 25. He claimed to have purchased from Abdul Hannan, son of Nosamia, that disputed land, lordship. Now, if your lordship kindly note that Abdul Hannan, son of Nosamia. Now, I have enclosed the original Khatiyan, lordship will get it page 21. In that case, lordship, that Abdul Hannan is there, but he is a different person, son of Abdul Motin. Because of that, lordship, he is claiming my land to be his. Page 4, your lordship, Abdul Hannan, son of Abdul Motin. Now, he is claiming that he has purchased from Abdul Motin, but that Abdul Motin is different. From whom he purchased, that is son of lordship Nosamia.
So there are land dispute admittedly, and to put pressure on the petitioner, this FIR was law. Anything, if anything is there, they will cooperate with the investigating officer, Lordship. And already that one of their brother is arrested, therefore they are apprehending that if they appear before the investigating officer with the documents, they will be arrested.
Mr. Borua.
Well, at this time, my lord, I'll pray for call for a case diary.
I think let them record this. There appears to be some dispute. Third, Ahmed. Stop. 482 bail application. The Bhumi PS case number 501 of 25. Two petitions. FIR, the concerned FIR dated 23/11/25 lodged by Niazuram. No, Niazuram. It is the against it is alleged that the accused persons broke into his furniture shop at late hours by breaking open the lock and destroyed the shop, causing loss of 3-4 lakhs. Mr. Ahmed, learned counsel summarized that the allegations are completely false and concocted. In this context, he has drawn attention to order dated 3/12/2025, passed by the learned circle officer Sri Bhumi, stating that the land covered by DAG number 318, Pata number 14, under Moza Borbari, same Moza, right?
Lordship, same.
Moza Borbari, Moza Borbhadri, is under the position of Hussein Ahmed Abdul Rahman Abdullah. That is the petitioners by right of inheritance, and that the land has been mutated in their name. The learned counsel submits that the petitioners have been trying to buy the land, and therefore this false case has been lodged. In the FIR also, land description has been given, which tallies with the descriptions referred to above in the order of the circulars. Therefore, while calling for the case diary, the petitioners, in my view, should be given an opportunity to record their statements. Call for the case diary accordingly. However, in the interim, 20,000 cooperate. Yeah. Is the matter?
22-1.
That informants tried to occupy their land. That
Informants tried to
informant.
The informant side tried to
Occupy that.
illegally tried to occupy the land.
Apply, Lord.
Number 10.
May it please your lordship. My lord, this is a pre-arrest bail application, my lord. The FIR at page 14, my lord. Whatever, my lord, this is a politically motivated case, my lord, between two parties, my lord. The informant side belongs to another political party, and my lord, they have named a political party in the FIR itself. Thus, petition number 2 belongs, my lord. It is a dispute regarding a plot of land, my lord. They say that, my lord, we have they have purchased the possessory rights from us, but we have till date not given them. And there was a, my lord, altercation on my lord, 2011, my lord, and the FIR was lodged on 27/11. That too after, my lord, a lapse of 1 week, my lord.
Shall we read it?
Lordship. Sir, respectful sir.
27/11, right?
27/11, my lord. Incident is of 2011.
Page 14, right?
Page 14. May I read, my lord?
Respectful submission.
A respectful submission is that I, along with 12 others, namely Habibul Ali, Azaruddin, Muhammad Ali, Suruz, Ajmal Ali, Qudus Ali, Ahmad Ali, Jainuddin, Ayam Ali, Hawa Khatun, and Hakim Ali have purchased possessory rights in respect of a land measuring 150 vigas located at so and so sor at consideration of rupees 1,30,000 from accused number 1 and 2. Despite paying the amount against the aforesaid plot of land, the accused person kept us footing for 5 to 6 years with excuse that they would hand over the documents today, tomorrow, whenever the written documents are asked for. On 2011 to 2025, the below mentioned accused person, along with a gang of 20-30 dacoits armed with knives, sticks, and spears, came and destroyed nearly 50 acres of maize field on the said plot of land using tractors of the accused number 4 and immediately showed mustard seeds in the soil. When I was when I and the remaining 4-5 persons tried to resist them, then the accused person started assaulting me and my companions with bamboo sticks. Left with no means, we barely managed to escape from the scene with our lives. They also assaulted Hawa Khatun, with who was with me by the punching, kicking, etc., and inflicting serious injuries internally on various parts of the body. Tore her clothes, grabbed her hair, and dragged her to the ground, outraging her dignity as a woman. It is noted that in reality, the individuals are criminals, records are operating as land mafias, goons illegally encroaching on several bighas of the village shore area, selling the same plot to 2-3 times to different people and accumulating millions of rupees illegally. The current perpetrators roam around the shore area from one corner to the other with weapons like dowel sticks, spear, and have threatened that they will forcefully take over all the land, even if it means killing me or anyone with me. The accused number 2, by virtue of being the president of the Youth Congress Party, he has been running this mafia style of my lord. Now, my lordship may kindly see one. They have said that we have not given position. Now they have said that they have grown maize field there, my lord. Maize field there, and only non-bailable section is my lord, the alias cheating and my lord, outraging the modesty. Others are bailable. No heart, my or only heart, my lord. No grievous heart. And moreover, the land in question, my lord, it is a grazing land, my lord. The question of selling to them does not arise because they could not show any money received or like that, my lord. They have simply mentioned that 1,30,000 we have taken and not given the possessory rights, my lord. And my lord, there is no grievous, actually nothing happened. It's a politically motivated case, my lord. Lordship may allow us to record our statement, my lord. My whole family has been implicated. And my lord, my lord, there was no alternative. And Lordship knows, my lord, the grazing ground, my lord, cannot be sold, my lord, to anyone. And they're saying that we have not given possession. Now they're saying that they have grown 50 because maize crops and we have destroyed that crops, my lord. I've categorically stated in paragraph 4, my lord, and 5, my lord, that, my lord, no. They belong to a different political party, my lord, and we belong to a different political party, my lord. That's why this altercation took place. Paragraph 5, my lord, we have categorically stated in 4 also, my lord. And lordship knows, my lord, the government grazing land, it's a, my lord. And my lord, no grievous injury, my lord. Nobody got any grievous injury, sustained any injury, my lord.
My lord, allegation is that, my lord, from the bare perjury of the FIR, my lord, that they paid 1,30,000 to purchase the my lord, possessory right from the my lord, accused person, my lord. But after passing more than 5-6 years, my lord, they have not given any documents or nothing, my lord. No.
But they have said, my lord, they have brought.
Let me submit. So this is the basic allegation, my lord, and after
And
that,
there is
my lord,
also
they
an
have.
allegation subsequent part of the FIR that they have been selling same plot to different persons
Yes,
again and again.
this is that. So, my lord, this entire fact will be clear from the case therein. I pay, my lord, to call for the case there.
Let the case that come till then some protection, my lord, because they have only in their FIR they have stated that they have grown 50 vigas in maize crops, my lord. If we
Heard SM counsel for the petition. Here is the allegations in FIR. At this stage, call for the case diary of Mongoldo PS case number 216 of 25. When can you get it? Before vacation?
My lord,
18th.
before vacation.
Try.
Before vacation, my lord.
Try. Since interim is not there. 18, 12.
Oblige, your lordship.
Made, please, your lordship. My lord, FITS page 9. My lord, main allegation is that petitioner is made, my lord, accused number 1, my lord, and all the doctors and his team, my lord. The petitioner is a gynecologist, my lord. Allegation is that, my lord, in his hospitals, the other accused persons forcefully aborted the, my lord, victim. And the FIR is lost by one, my lord, president of a, my lord, NGO. And, my lord, after 2 months, my lord. Lordship, may I read the FIR, my lord? I am the doctor who treated the, my lord. Humble submission of the undersigned is that she is the president of
No, just a minute. The FIR is dated 4/11.
4/11 and incident of it was 6/9 and 7/9, my lord. She was admitted in that hospital.
Several accused persons.
Several accused persons, and we are the 8, my lord. I am the 8, my lord. He is the in charge of that hospital, my lord. Humble submission
All
of the
doctors on team of hospital.
my lord, all doctors, but my lord, police, my lord, when serving the notice, they, my lord, inform that they will arrest the.
I've understood.
Humble submission of the undersigned is that she is the president of ISRPC, it is a, my lord, NGO. That the victim, namely Musammad Khuzeda Begum, by written complaint, informed our organization seeking legal assistance as she belonged to a very poor and uneducated family, and she is getting threats from the accused persons, and also become very weak due to abortion of 5 months pregnancy. As a respectable citizen, the complainant lodged the present complaint to give justice to the victim. That from last 1 year, the accused number 1 made physical relationship with the victim with pretext of false love, and when the victim number 5 became pregnant, victim became 5 months pregnant, the accused number 1 with ill advice of other accused persons forced the victim for abortion and told that he will marry her socially if she goes for abortion. The accused number 1 had some photos of the victim and he threatened the victim if she is not getting abortion, then he will viral those photos in the social media. The pregnancy of the victim was forcefully aborted at a Royal Nursing Home. That is the petitioner's nursing home. The accused number 1, Riazul Islam, in association with the other accused persons, got married with the victim with reason. That is another person after the abortion. Then that when the victim came to know about the marriage, she talked about the abortion incident with the accused number 1 and the other accused persons. Then the accused person scolded and let out the victim. That the accused number 1, along with along with his brother-in-law, accused number 2, made viral some bad photos of the victim in the social media. To save the accused number 1, the accused number 5, 6, 7 took money from the accused number 1 as a middleman and forced the victim to hide the incident. The accused number 3, 4 threatened the victim that by saying that what she would do after knowing the abortion incident. The accused number 1 married the victim for 2 quarters of land with then it should be nephew of the accused number 5. That is the allegation, my lord. Let's come to page 21, my lord. She was treated from 6 to, my lord, 7, my lord. 8 on 8 she was discharged.
They have got married now.
They have married the my lord, victim with another boy, my lord. That is the allegation. But forceful, so my lord, she was treated. I have annexed the medical document.
Riazul Islam is the doctor.
No. This is the Gobind Chakia. He is the doctor. Accused number 8, my lord, Royal Treat Hospital, Research Center, all doctors and
He's a doctor.
the police came and harassing.
He conducted the abortion.
No, actually that was not abortion, my lord. That is in the medical documents I have. It was a, my lord, automatically. She came with a, my lord, lordship, come to page 21. Cessation of 4 months, man's 4 months.
Just a minute.
Bleeding, page 21, my lord. That is the medical record, my lord. Page 21.
Cessation of menstruation 4 months.
And bleeding PV, pain abdomen. So in this situation, she came, my lord. Thereafter, lordship come to the next 22 page. IPO at 16 weeks of pregnancy, threatened abortion. It was, my lord, pain was there. So pain abortion. Then, my lord, lordship come to page 25, the first line. At 9 a.m., patient is restless, my lord. Then 9:30, patient is on OT table. She was taken to. Then, my lord, these are examinations. She only cleaned, he only cleaned, my lord. And in the medical MTP register, my lord, I have annexed page 39 because it was not a, my lord, MTP. So her name was not there.
No, it was not an empty.
No, I know not MTP, my lord. It is, my lord, let him appear and
Miscarriage.
miscarriage, my lord. So let him appear and produce that all documents and
Because I thought that these allegations against the named are little
my lord.
serious.
Serious.
Yes.
Well, in the FIR, my lord, there is no specific allegation directly against the doctor.
Yes.
Only allegation, my lord, against the nursing home. Now, my lord, police has asked for some documents, my lord.
Detailing photos and all that. These
All
are
right.
Documents, my lord.
And also threatened, my lord, that they would be arrested. So, my lord, he may be protected, my lord.
They have already annexed those documents along with the bail application, my lord.
Yes.
So let these documents be produced before the IO, my lord,
Yes.
for the purpose of.
And record his statement, my lord. Petitioner statement.
heard. Arjib. Invoking 482, the petitioner, Dr. Gobind Sakya, stated to be the proprietor of one Royal Hospital, Khilmati, Lakhimpur, is seeking anticipatory bail in connection with Lalu PS case number 224 of 2025. Stop. The case arose out of an FIR dated 4/11/25 lodged by Sahiba Ahmed, who stated to have be belonging to some social organization. 7 persons are named in the FIR, and also Royal Treat Hospital and all doctors and his team. Full stop. The FIR narrates various allegations against the named persons, especially against petition accused number 1, Riazul Islam. Full stop. The present petitioner is not not mentioned by name in the FIR. It is submitted that he has been implicated because the backdrop of the allegations with regard to the other petitioners and the other accused persons named in FIR. The alleged victim woman had undergone what should I call that? Natural abortion. Natural abortion / miscarriage. And the petitioner as doctor had attended to her. The
It was done in his nursing home.
it was done at his hospital. The medical documents have been referred to during the submission. Call for the case diary. However, in the interim, the event of 20,000 with 10 to the commission. Will cooperate with investigation. Appear before record his statement. Appear for make himself available for examination. He is also at liberty to produce documents for the IO. It will be good for you to commit these documents.
21-1, man. 21-1.
21.
High level admin.
Yes.
May it please your lordships. Lordships 482 application. Lordships, the allegation is under section 69, lordship, with 356 2 and 3, lordship. The affair is at page 16, lordship. Herein, one Shabnam Begum of Dibrugarh has alleged that for last 3 years, the accused person and his family have been promising to marry me. They told me that once the construction of the house was complete, they would come to my home and formally speak about our marriage. Relying on this assurance, I entered into relationship with him. However, during these 3 years, instead of keeping his promise, the accused Muhammad Ali has subjected me to severe physical, mental, sexual exploitation on several occasions. He has beaten me mercilessly. All these allegations, lordship, similar allegations. And the lordship, this is Disney PS case, and I would like to draw your lordship's kind attention to page number 23 and 24. The informant alleges that with the promise of marriage, she has been exploited. But the fact is different, lordship. The accused and the informant were classmates in USTM, lordship, during their study of LLM, lordship. And love affair started, and thereafter, subsequently, they broke up the relationship. Page 23. this is her own handwriting, Lordship. I, Shabnam Begum, with my sound mind today, I have cut down all the ties with Mr. Muhammad Ali, and I hope that Mr. Muhammad Ali will not try to contact me in future. Along with this, another document, Lordship, at page 24, Declaration of Mutual Breakup, Lordship. This is a new kind of instrument, Lordship. Mutual breakup. To avoid any complicacy in their lives, respective lives, Lordship. Herein also she has declared.
Not a bad idea.
Lordship,
Anyway,
so the case diary may be called for at this stage, Lordship.
But that's true.
Lordship.
But that is your instruction. But she has made a lot of allegations.
Lots of allegations.
Elements of rape is also there. Actually.
Lordship, as per my instruction, Lordship, till date she has not even recorded 161 statement and 164 statement, Lordship. She did not go to business. And the entire affair was at Guwahati, Lordship, and she is from Dibrugarh. She filed the case at the native place of the accused, Lordship, only to harass him, Lordship. So there she did not go. Till date, neither her 161 has been recorded, Lordship, and the petitioner is a lawyer, Lordship, practicing in the High Court as well as in the Business Court, Lordship. And the iCard is here, Lordship. His iCard.
I've seen.
At page 25, Lordship. Lordship, at this stage, I may be protected, Lordship. Truly love story, Lordship. They broke up and she is engaged with some new guy, Lordship, namely Asif. And in order to avoid any disturbance from this petitioner, she has filed this.
But so many allegations.
Affair, Lordship. Affair is there, Lordship. Allegations are there, Lordship. I admit, Lordship.
This is AB, right?
AB, Lordship.
Typed it wrongly, 482.
Yes, Lordship.
Anticipatory
connection
with Disney case number 124 of 25. Informant has been lost by the
page 16
one S Begum. The allegations that for several years the petitioner and his family had promised to marry her, and she entered into a relationship, but subsequently she suffered physical and sexual abuse at his hands. She is also alleged about his spreading defamatory statements about her in the locality in collusion with others, and also having illicit relationship with others. Because the ending the relationship might be out of this also. Okay, he'll record a statement.
The affair was filed later on.
But thing is that the ending might be in the backdrop of all these things also. Right?
First they broke up and there are years filed this
I've
affair.
drawn my attention to
These documents, what my learned friend has annexed, that we cannot take into consideration at this stage. Provided it is in the
annexed
case
documents purportedly written by the alleged victim girl.
These are handwriting.
About ending her relationship. See, wedding card is also there.
No,
But they are
wedding
not
card was
married.
posted by her, Lordship.
They are not married. No, I think there's some elements of truth. Anyway,
that is from her
Petitioner
profile,
is,
Lordship.
stated to be an LLM and practicing advocate.
Both are major, Lordship. There was love affair. They were classmates, Lordship. They stayed at Guwahati, Lordship.
Love shouldn't go wrong. Anyway, it's not my right to say. I have no right to say.
If they caused a
Call for the case diary, but given
then before the vacation,
in
Lordship,
the
you-
event of his arrest, so allowed to record 25,000 at once, subject to the condition. Cooperate with investigation, appear, make himself available. Arvata condition. He shall not in any manner intimidate, harm, or harass the informant, or commit any illegal activities which is detrimental to her to her safety and dignity.
21.
21.
deeply obliged, Lordship.
The more we have, the more educated a person is, the more responsible a person holds, the the social conduct is expected to be even
My
higher.
lord, exactly,
Like
my lord.
lawyers we have, then other people, if people expect.
All right.
We have to live up to that standards. Really.
Hearing BA 21.
This case earlier, your lordship has granted interim protection on 25/9.
Yes. It's a regular bill.
Yes, I will. Let petitioner advocate may come.
Oh, it's not there? There is come.
Diary received, FSL report may the same, not yet received.
Not yet received.
Not yet received.
So should we wait or?
Your lordship may made absent, otherwise will your lordship may fix any immediately after vacation.
We'll wait for some time.
Yes.
ভুল হইতে পারে। বলবো না।
Call for PCR. Lordship, it has been submitted. Now, PCR. May I please, your lordship, my lord, here in this case, my lord, I am appearing on behalf of Mr. D. Decca, my lord.
Yes, no.
My lord, oblige, my lord. My lord, here, my lord, your lordship may kindly see the FIR, my lord. Page 13, my lord. What happened, my lord? Some materials were stolen by some persons, my lord. Nobody named, my lord, from some electricity office, my lord. And what happened, my lord? This petitioner, before your lordship, my lord, he is the owner of a scrap material shop, my lord. The person who has stolen, they sold it to this petitioner's shop, my lord. It is mentioned in the forwarding report also, my lord, grant of arrest, my lord. And the person who has stolen, my lord, he has been granted bail by this honorable court, my lord. That order is page 17, my lord. That Rafiq Ali, my lord. And I am in custody, my lord, near about 63 days today, my lord.
The FIR is at 13.
Page 14, my lord. 13, my lord.
Yes, sir. I have a look. Huh?
13, my lord.
Critical conduct. Stolen.
Section charge, my lord, 3032, my lord. Theft. Thereafter charge sheeted, my lord, your lordship has called for the scanned copy of the TCR, my lord. That has been received, my lord. Forwarding report page, my lord, 14, my lord. In the ground of arrest, it is
In the case, nobody has been named.
nobody named, my lord. But in the forwarding report, it is stated, my lord, ground of arrest, my lord, page,
Yes, yes.
page 14, my lord.
I'll see.
1, 2, and 3 paragraph, my lord, ground of arrest, my lord. He said Rafiq Ali has, my lord, sold it to the petitioner. He purchased it on consideration of rupees 30,000, my lord. The person who has stolen, he has been granted bail, my lord, and he is the bona fide purchaser, my lord. He had no knowledge, my lord. He is the scrap material shop owner, my lord.
But I have perused the scan copy, my lord. From the scan copy, my lord, yes, my lord, he has stated that, my lord, he has purchased those stolen goods, my lord. So knowingly or unknowingly, my lord, his
And
trial
that
will say, my lord.
Nowadays, many rackets are going on.
Yes,
Yes,
my
my
lord.
lord. And secondly, my lord, this stolen article, has been recovered from his possession, my lord. It has
I-
already also been changed, my lord.
Yes, that
So the trial has not yet commenced, my
No,
lord.
you don't have to admit. That's an allegation.
my lord,
Subject of
my
trial.
lord, my lord.
Subject of trial.
That I admit, my lord, I have just purchased it, my lord, from Rafiq Ali.
This order sheets are not necessary. Okay. This test, let them face the trial. What is the stage?
This is not that, my lord, it is for the appearance test, my lord.
My lord. That page 17 is the order, my lord, court case.
Charge sheet file on 30/10/2025.
Appearance.
No, charge sheet file, my lord. Charge sheet.
You don't need, you can take from here, huh? Page 18. Page 18. Second para, para and fourth para, allegations is same. The investigation, upon completion of investigation, the case was charged sheet, and the present petitioner was also sent up for trial. He was arrested in this case on
11/10, my lord.
11/10/2025. It is submitted by the learned counsel that one co-accused against whom there are graver allegations have been has been enlarged on bail. Which is this order? Is it any?
Page 17, my lord.
Yeah, this is order. Three accused. Huh?
3 accused have been granted bail.
3 accused against whom there were graver allegations have been enlarged on bail. The learned additional PP submits that the main implicating materials against the present petitioner is that he purchased the goods which were subject matter of, which were allegedly subject matter of the theft. Nevertheless, the case is stated as the case is stated to be at the stage of appearance and poised for commencement of trial. I allow this bail petition, and accordingly I have to go on 30,000 with one surety of the like to the satisfaction of the
CGM Baksha at Mashalpur, madam.
And subject to the conditions that number 1, he shall be available for trial upon commences. Number 2, he shall not hamper or tamper with evidence. Number 3, he shall not commit any illegal activities or offenses. Violation of the bail would entail violation of the bail conditions would entail cancellation of the bail. Bail petition stands allowed and disposed of.
Hello, Lordship, before my lord, 24 and 41 similar lord.
Also same FIR, my lord.
Same FIR.
Maybe
24
taken together.
41.
41.
41 is AB.
AB, my
AP, lord.
See that? We can take it up. You have all both.
both, my lord.
You have both.
Both the matters may be taken up together, my lord.
41 to the 41.
Charge sheeted case.
41 to the
Subsequently, we came to know about the charge sheet, my lord, and we have also collected the certified copy of the charge sheet, my lord. Although the FIR has been registered under non-bailable sections, my lord, but on perusal of the charge sheet, my lord, all the sections which are labeled against the petitioner, my lord, are bailable in nature, my lord. And
Azahar is a 10.
page 10, my lord. May I read the FIR, my lord?
Lots of allegations in that.
My lord, there are although allegations,
Too much of allegations.
but under the sections under which charge sheet has been filed, my lord, all are, my lord, bailable sections.
Your lordship, as there is his personality is
I don't bother about religion, but thing is that the hiding identity,
lordship.
and forcefully converting someone. These are dishonest acts.
Yes,
That is
my
why they should be.
That is there, my lord.
We should be, we should never encourage, isn't it?
Lordship.
My lord, kindly peruse the charge sheet, my lord.
Otherwise, he has a 4 wives, lordship. After marrying her, again another girl, he married lord.
That is another.
And
Forceful
and
conversion is also done.
allegation.
Allegation.
But sons of the first wife comes and she says that they threatened to rape her.
Lordship.
I don't.
Son of the
I
first
mean, if it's true.
lordship.
These are, my lord, very vague allegations.
And her 14083 statement is
Values
also
have
their lordship.
collapsed or what? I don't know. So what should I see?
My lord, kindly see the charge sheet, my lord, under which the charge sheet has
Otherwise,
been
it's-
filed.
okay.
These are, my lord, section 319, 82, subsection 1, section 85, 115, subsection 2, 351, subsection 2, and 3, subsection 5, my lord. All are available sections, my lord, and the petitioner is behind bars for 66 days, my lord.
In this case, I want to state here, lordship, on focus on two things, lordship. Here, the charge sheet has been submitted on 6/12, very recently, lordship.
6/12.
6/12. And it was fixed on next date is 29/12 for appearance, lordship. And since if we look into the FIR, lordship, threatening is also there. Till her lordship evidence has been taken of the victim, lordship.
Witness, evidences start out is
No, no,
My
no.
lord, there are
180 only lordship her 164 or
8
180
witnesses are
statement
there,
is
my lord.
lord.
8 witnesses are there as per charge sheet, my lord.
Only lordship victim statement, lordship, deposition.
Yes, my lord. And I may be allowed to, my
But
lord,
he has not,
face the trial, my lord, under any condition.
No,
my
no,
lord.
there is
Since-
a
Since the section under which the charge sheet has been filed, my lord, all are available section, and I am behind bars for 66 days, my lord.
threat may be there, lordship.
I may be, my lord,
Because in
put
the
under
FIR
any
itself
stringent
it is
condition,
there,
my lord. I'll, my lord, abide by the conditions imposed by this honorable court, my lord. And my lord, as far as the concealment of identity is concerned, my lord, even upon perusal of the first paragraph of the FIR, my lord, it is stated that he developed love and affair with me and engaged in physical relationship, and later he informed me that his real name is so and so. Approximately after 6 months of their relationship, my lord.
That's
Thereafter they got married.
any kind of
will be done.
misrepresentation of identity,
Yes.
about qualification,
My
about
lord,
job.
it is there, my lord.
Because see, what is misrepresentation? That if I had known this fact, my decision might have been different.
Different.
So that is misrepresentation. I might have taken the same decision, but it might have been different also.
We are lordship 69 is not added, but it should come, lordship, in BNH.
I'll go through it thoroughly.
Kindly, my lord, consider the
Give me some
charge sheet, my
time,
lord, and the sections under which charge sheet has been
Otherwise,
filed,
it
my
is
lord.
at the stage of trial, no doubt.
Yes,
But,
my lord. And I am
this-
behind bars for 66 days, my lord.
I'll read. Please never think that I'll be biased or something. Never. Religion or never.
Lord,
No, I assure you. But these kind of things, let's see. If there's
And
no
my lord-
threat to her, I am convinced. Then okay.
In item 41, my
Otherwise,
lord,
for some time, till she's examined.
in item 41, my lord, they are the wife and sons, my lord, as per the
Wife, other wives.
yes,
Fourth wife, lord.
fourth wife and the
Fourth
sons.
number.
For them, it can be considered.
Yes.
I agree with it. For them, perhaps it can be considered.
My lord, my period of detention may be considered, my lord, and
Otherwise, I said, no, it's
yes,
at the stage of
66
trial.
days, my lord.
Ideally,
8 witnesses.
everyone
there,
should be
my
on
lord.
bail. Ideally.
Any condition, my lord, as your lordship deems fit, my lord.
Just give me.
My lord. Much obliged.
Item 21. I'm sorry, my lord.
No, sorry. Keep for it. Yes.
My lord, by order dated 25/9/2025, your lordship was pleased to grant interim bail in exceptional circumstances, my lord.
Abatement, yes. Abatement,
Yes, ma'am.
allegation.
The opinion regarding the death and the FSL. FSL, my lord, today also, as per report of the IO dated 11/12, till today, my lord, FSL report.
But diary is available.
Case diary available.
Make it absolute.
Yes.
Or should we fix it after vacation? FSL will it, because the investigation, otherwise, does it indicate abatement? Some kind of allegation?
FSL, my lord, no.
Materials? No.
Otherwise, my lord,
Leaving aside the FSL,
yes. Otherwise, yes, regarding mental and physical torture, my
Torture.
lord, that
Cruelty only.
Inference must have been given for some reasons.
He was 18 days on custody, my lord, in jail, my lord.
mental torture.
Some other expired. Then.
Yes, ma'am.
Anyway, let us wait for this.
Yes.
You'll send back the case diary.
Yes.
Yes. Stop. The petitioner was granted interim bail on 25/9/2020. The case diary is available, but FSL report was called for, but the same is not yet received. The case diary may be returned back and procured again along with the FSL report. Stop. The interim bail granted by the order dated 25/9 stands extended till the next date of listing. Fix on
My lord, 19-1.
19.
Public.
25, please.
May I please your lordship? Last time FSL report in the postmortem report, the case diary was called for by your lordship.
25, my lord, in this case, as per my instruction, search sheet submitted, my lord, in this case.
Petitioner is aged 18 years.
18 years, my lord.
What happened?
And it is 60 days in the judicial custody, my lordship.
Your father informant.
For informant.
What had happened? Oh, I just lost it and with 5.
Trial court record may be called.
Just one girl is also there.
Yes, sir.
Minor girl. No. The FIR
Yes.
name in the FIR name, the list of FIR name they used one girl is.
As such, it was filed, but the lady may be before a trial.
Tell me. Charge sheet is appeared.
Search sheet submitted. My lord, in case of appearance in the trial court, my lord, only trial court after perusing the materials, only trial court, my lord, consider his bail application in accordance with law. In case of, my lord, no, otherwise, my lord, scan copy of the TCR may be called for.
You will approach trial.
Yes, trial.
Lordship, if it is come after the 12th of January, then 90 days will be complete, my lordship. Even it is a section 103 is attracted. So it will be no good thing for me because ultimately if it is come before the 12th of January, my lordship, in the 4th or 5th of January, and maybe lordship may be called for the trial court. Trial court record. If it is come before the 12th of January, my lordship,
Submitted, my
Charge
lord.
sheet submitted.
Charge sheet
90
submitted.
that will not come. That
Let him approach before the
that's
trial.
why I'll face the trial, my lordship. So I'll take the regular bail from this.
At this stage, if it's before magistrate, it will be difficult to grant bail because it's a
Yes,
302 case.
Yes, my lord.
So,
Record will be coming.
huh?
Record will go to session court.
Already, then it's not so.
Only
Session
trial
can
court
give.
will consider, my
No,
lord.
no, sessions can give.
Yes, session case.
Lordship, yes, because this charge sheet is filed, so I may be allowed it to face the trial, so I'll approach the session court, my lordship, for that.
No.
That may be reflected in the
The case
judgment.
arose out of H3 PSK and the incident petition has been filed seeking regular bail in connection with H3 PSK case number 92 of 20 under section 103. Yes. The present petitioner is one of the 3 persons named in FIR with the allegation that they had murdered the minor daughter of the informant. Full stop. The case diary has not been received, right? Case diary has not been.
Case diary not received.
Case diary was called for, but the learned additional PP submits that the case has been charged sheet. So, third for the informant, learned counsel petitioner counsel submits that he is also willing to approach the learned trial court for the bail. The bail petition is disposed of with the observation that the petitioner may approach the learned trial seeking bail, which needless to say shall be disposed of after considering the materials. Stays of the case.
Deeply obliged.
Well, in this own case, my lord, petitioner prayed for bail, my lord. Yeah, my lord, what is happened, my lord, actually, my lord, in earlier occasion, there was one case, my lord. In that case, he was granted bail. That is page, my lord, page 25. Starts from 24, annexure 5. First, your lordship kindly peruse the FIR, my lord.
Yes.
FIR page starts from, my lord, 12, my lord. And 13 is the relevant one. When is allegation of, my lord, sitting of rupees 7,50,000, but when he was paid, he was actually, my lord, the informant himself, additional deputy commissioner. Why he has, my lord, invested there, my lord, I don't know, my lord, but here it is mentioned. But subsequently, my lord, immediately after some days, he has lodged his Ezahar because accused petitioner was in jail, my lord, already, my lord. And shown arrest bail order is, my lord, kindly peruse your lordship, page 17, my lord, annexure 3.
Sorry, sir. Just a minute. Long.
Investment of share market. Informant himself, additional deputy commissioner of the verification why here.
Anyway.
Yes, page 17, my lord, kindly peruse your lordship. Page 17, annexure 3, shown arrest, it is page 18, it is mentioned. Considering nature of gravity of offense, IPO prayer, the shown arrest of the accused person is allowed. Remand the accused.
He was arrested in another case.
Yes, my lord. He has been granted bail in that case, my lord. I have annexed here, my lord. Here, by this honorable court, page 24. Already 139 days behind the bar.
Same kind of allegation.
Yes, my lord. Already he has learned the lesson, my lord. Already is out of the Assam person, my lord. Already would be able to. It was 25,000 rupees IPO, etc., my lord. Investment of IPO. But actually here it is mentioned, my lord, there was some agreement between the parties, my lord, for staying in the homestay, etc.
My lord, page 22, third paragraph, my lord. Page 22, order sheet. Third paragraph, my lord. The fourth line, my lord. That the accused has several other cases against
Third paragraph.
Page
Fourth line.
22, my lord. Third paragraph, my lord.
Yes.
Fourth line, my lord. That the accused has several other cases against him pending in Gorakhpur as well as Haflong and
Appears to be habitual.
yes, habitual.
That is there, but
And only
it's not
because
mentioned.
complainant
Alleged
is the
habitual
DC, my lord, that cannot be a ground that, my lord, DC cannot be, it cannot be said that, my lord, he cannot be, my lord, seated by the accused person.
Yes.
DC, anyone maybe, my lord, he is
He
involved.
invested that. Already he was in jail. Thereafter, why he has
On being induced by
It's
him,
not
he has
believed.
invested, my lord.
not induced? He was already in the jail, no? From 26/7, my lord. 139 days already behind the bar, my lord.
No, in this case, he was shown arrest on.
My lord, in this case, 10/10/25. Bail reject order is also there. 31/10, my lord. Annexure 4.
Lordship may fix it on, my lord, 18, I will get
Is
it.
60 days more over in this case? 60
Yes.
day offense?
No, my lord, 90 days offense.
90
Peter. 90 days. Today is 64 days.
Nice. No, investigation, tell me the status of the investigation.
Still APR, my lord.
Otherwise, it may not be prudent to grant bail at this time. Investigation, in this case, what has it revealed?
Well, no, CD not received, my lord.
Oh, CD has not?
CD not received.
Oh, I see. Sorry. We'll call for the CD.
Yes.
Reminder.
Before, my lord,
It comes, so
last day, my lord.
case diary is not yet received. Issue reminder for the case diary of Haflong case number 59 of 2025. The accused was arrested on 10/10/2025. Was shown arrested.
Shown
In
arrested,
this
my lord.
case, on 10/10/2025. This is the matter on
19 on.
No, 19 will be later.
Oh, no, sorry, 1912, 19.
Nineteen 12.
Because yes. And 27.
May I please, your lordship?
Date 19.
Yes. May I please, your lordship? Also, regular bail application, lordship. Petitioners are behind the bar for last 29 days, and the statutory period is 60 days, lordship. Lordship may kindly come to the FIR, page number 12. The allegation is that, lordship, two persons from lordship Madhya Pradesh came into contact with a person named Vikram Nath through online, lordship. And then they were called to lordship Guwahati. Their lordship, they were lordship. Then two person were sent by this Vikram Nath, and the complainants were shown lordship certain gardens, tea gardens and lordship their Vikram Nath gardens, and they were lordship asked to invest. And they were lordship assured that within some days the goods should be delivered to their destination. And later on, it was alleged that lordship they were kept to a place, and their lordship they were locked in a room. And there 8-10 people came, and they started a lordship to take away their belonging, lordship. It is alleged that lordship 5 lakh cash, 6,000, 5 lakh rupees cash, mobile charger, power bank, hotel key, iPhone, etc. were taken away, lordship. And thereafter, lordship, they managed somehow and to escape from their lordship. This is the allegation. And so these two persons are not named in the FIR. They are no way connected with the principal accused, lordship Vikram Nath.
Diary.
Yes, they received, my lord. Actually, my lord, name of one person, Vikram Nath, is stated in the FIR, and one mobile number was also there in the FIR. But in fact, during investigation, it comes to light that that is not, my lord, mobile number of Vikram Nath, but that is one of the present accused petitioner, Nabi Hussain, my lord. Therefore, only by tracing that mobile number, my lord, police arrested Nabi Hussain, and from his possession, that mobile was also recovered. And thereafter, on the basis of his, because a gang is involved, my lord, in this manner, initially by inducing all the persons from outsiders, then thereafter when they came along with money and all these things, thereafter they looted all these monies, and not also provided the, my lord, the materials which they were initially, my lord, promised them to provide. So, my lord, there are materials against these accused persons. Only after tracing the mobile number of that Vikram Nath, it was later found that Nabi Hussain and the present petitioner Riazul Hussain is involved in committing, along with other associates is also there. Those were not yet arrested, my lord, and those money looted from the present petitioner were also not yet recovered.
Money is recovered,
No, my lord.
yet to be recovered.
Yes.
483 bail application, seeking regular bail in connection with Nagam
Lordship,
PS case number 90.
They will face the lordship, they will cooperate with the investigation lordship. Because lordship and
Arrested on 14/11/2025. The FIR is dated 12/11/2025. Lost by one. Gyanendra. The gist of the allegations is that they were induced by one person, Vikram Nath, to see tea gardens which were being for purchase at a cheap rate, and accordingly they went there, whereupon they were taken to another locality and locked up in a room, and subsequently several persons came and snatched away their money and other valuables. The case diary has been received. Learned additional PP submits that the mobile phone that was being used by the named accused Vikram Nath was found to be belonging to the present petitioner, Rabi Hussain, one of the present petitioner, Rabi Hussain. They submitted that the investigation has revealed the involvement of a gang in these activities, and the robbed money is also not yet recovered. The given facts and circumstances, considering the serious nature of the allegations and the implicating matters, the bail petition stands rejected at this stage, returned back like this to some time.
obliged.
May it please your lordship. This is a 483 application, your lordship. In fact, on the last occasion, the PM report was not there, that was called for. And in fact, today it is 91 days. So if charge sheet have not been filed, then he'll
Will be entitled. Just
Yes, my lord, CD is available, my lord, and FSL report also revealed, my lord.
not complete.
Result of examination, my lord, gave positive test for organophosphorus insecticide.
So she died by taking, your lordship, some insecticide, poison. And later on, the FIR was filed against the petitioner, saying that they have given it, but in fact, it was a matter of suicide, which was the, but since 91 days have passed, that is the issue.
Otherwise,
If all bail.
regarding materials, there are sufficient material regarding physical and mental torture, my lord. Regarding that aspect.
Two point.
CS not yet submitted.
Third, it's Mannan, and learned additional to CP Botaku. Invoking 483.
Okay.
The two petitioners are seeking regular bail in connection with Ajo PS case 386 of petitions. They were arrested on 12/9/2023. The learned petitioner counsel, Mr. Mannan, submits that as on today, the petitioners have completed, you've calculated,
91 days.
Calculate. Have completed 91 days in under trial detention. This case diary has been received.
Yes.
And along with FSL report indicating poison in the viscera. However, investigation is not yet complete, thereby entitling the petitioners to default bail. Accordingly, they are allowed to go on bail of rupees 40,000 with one surety of the like amount. The satisfaction of the concerned learned court, GMFC Hajo, and subject to the condition number 1, they shall be available for trial if one commenced. They shall not hamper or temporary evidence. They shall not in any manner harm, harass, or intimidate the informant, family members, and also not try to influence with violation of bail condition shall entail cancellation of the return the case then.
Two petitions. There are two petitions.
Two, yeah.
Obliged.
They likhibho, they. Yeah.
May I please? My lord, this is my lord a regular bail and lordship will find at page 9 is the my lord affair and he's already in 32 days in custody. My lord. Page 9 is the my lord affair.
Yes. Diary has come.
His areas come. Victim is implicated, my lord, to take that extent, my lord, that in the night, my lord, the other person, the other co-accused, my lord, he has
Kidnapped.
not kidnapped, my lord. He was actually, my lord, he was at night, my lord, he stayed in the house of the my lord, the other co-accused person, my lord, as requested by her because he could not return her house, my lord. Thereafter, my lord, in the night, my lord, the
They tried
co-accused
to
person,
assault her.
the co-accused person, my lord, he has, my lord, to give a proposal to her, my lord,
With
that his senior will, my lord, stay the night with her, my lord. This is the allegation basically in the case that. Offer to pay 3,000 rupees.
Now, considering the my lord, detention period.
That is true. Arrested on.
Arrested on my lord. Iman Nasilga. This is one. Arrested on my lord 10/11/2025.
Well, her statement is there.
Yes, madam. Yes, ma'am. He came for some photo shoot.
Yes, yes.
Then
These
the
are
night
professionals. They have to travel.
Yeah.
This kind of
He could not
professions
travel,
require,
my lord, that is
require
why-
traveling.
He could not travel to her house.
Yes, yes. They
So she
require
was
traveling.
offered to stay in his house.
Yes, yes. These things are there. It will be difficult for women to kind of these things. Anyway, let me see. Must be knowing these persons to some extent. Otherwise, someone will not
Definitely,
stay
my lord. Actually, my lord,
a
as per her
stranger's
assessment, my-
house just like that.
Yeah.
Especially a lady.
No, the other co-accused, my lord, he is the person, my lord, who offered her the photo shoot. And after the photo shoot, my lord, when it was become, my lord, dead, he could not return her house, my lord.
Customer.
Then, my lord, yes. Then, my lord, he offered her to stay in his house.
Right.
But in fact, my lord, he has taken to the house of this main accused person, petitioner house, my lord. And in the night, my lord, she was offered 3,000.
They are proportionally known to each other because of their my lord, profession.
Young lady.
She's married also.
That doesn't matter.
M.U. Mondal.
Yes. 483 bail application seeking regular bail for Sakir Ali. Connection with Kazigaon PS case number 70 of 2025. Understand. He was arrested on 10/11/2025. The fire was lodged by the alleged victim woman herself, narrating detailed allegations. The gist of which is that as part of her work, she had gone to Dhubri for a photo shoot regarding a shop, and as she could not return, the said person, of the shop took her offered to let her stay in their house, but he took her to house of another person where that person tried to have sexual relationship with her and offered her some money for that. And subsequently, she could contact her husband, and he was rescued from that place along with police officials. Good stuff. The case diary has been received. Investigation is continuing. Her statement has been recorded before learned JMFC, in which she has supported the allegations made in the FIR, and the same has also been corroborated by the statements of independent witnesses. And considering the nature of the allegations and the materials, the bail petition stands rejected at this stage. Return the case diary.
Obliged.
Mayor's Lordship. FIR case 9 Lordship, identified 57 days behind the bar Lordship. Petitioner was arrested on 17/10/25 Lordship. Answer case 9 Lordship.
Yes, 9.
Nice. May I request? With due respect, I beg to state that on last 15/10/25 about 1 a.m. Lordship, above mentioned vehicle by December so and so, and 5 numbers of youth boarded on the vehicle along with another Baleno car illegally entered into my house and assaulted me and my wife, namely Bharati Voro, by showing sharp weapons for committing dacoity and threatening. They had taken away bail metals, utensils, and cash amount of 80,000 from our room. They had also taken away 2 numbers of white color pasture goats and 6 numbers of camel goats from our cow shed by breaking the lock of the taken away the aforesaid Baleno vehicle. Immediately, we were starting to hue and cry. Then the neighboring and local public were came to know the incident. They followed the 2 vehicles and stopped the aforesaid vehicle by station number 7 along with the 5 numbers of youths at North Guwahati, Radadwar, from the front side. While we were inquired about the incident, then the accused person hit our vehicle by the aforesaid vehicle. Immediately, we hand over the vehicle along with 5 numbers of youths and various weapons used for dacoity and 6 numbers of mobile phones to the Bidar Saheli police station. Sir, this mentioned that since 1 year, about 150 numbers of cattle and goats have been stolen from Greater Langa Kuru area. This is the FIR. Lordship, as per allegation, they caught red-handed, but nothing has been recovered from their possession, Lordship. You should consider detention of 57 days as on today, Lordship. Only on sufficient ground, they are apprehended in a road, Lordship, national highway, but nothing has been recovered from their possession. They have collected seizure list also, only mobile phone and 1 screwdriver, Lordship. On the basis of wrong information, they have been arrested, Lordship. Nothing has been recovered from their possession, Lordship. If they are arrested red-handed, some may be recovered, Lordship, from their possession, Lordship. as well as in the FIR, Lordship.
Okay.
Yes, my lord, case they received, my lord. And at the time of commission of the offense, they used two vehicles, my lord. One Swift Desire and one Baleno car, my lord. And on the basis of, after the, my lord, this informant, my lord, making hue and cry those, my lord, and thereafter intimated their neighbors
Yes,
thereafter, my lord. One, my lord, Swift Desire vehicle along with all these accused persons apprehended by the local public and thereafter handed over to the police. And thereafter, my lord, the other, my lord, regarding, my lord, Baleno vehicle, my lord, they, my lord, escaped from the place of offense. And regarding some of the goats of the, my lord, in that area, my lord, regarding this type of
Yes.
theft is continuously.
Identity of this persons.
Yes. And regarding the present accused person, they were caught red-handed by the public and thereafter.
Red-handed.
Red-handed, and thereafter, my lord, handed over to the police along with the, my lord, Swift Desire vehicle.
Can I have?
Lordship, if you got red-handed, then nothing has been recovered, Lordship.
Some
Allegation is
of
got
the
red-handed,
items,
Lordship,
these are
but nothing has been recovered from the person, Lordship. No, no money, no got.
It's a 90-day offense.
90 days of 310, my lord.
Only 331, Lordship, 14 days. Otherwise, Lordship, all are 10 years, Lordship. Extended to 10 years, Lordship. As in today, 57 days, Lordship.
No.
So only one section, 14 years, 331 subsection 6 punishment for house trespass, Lordship, and house breaking at night, Lordship.
While they were fleeing away from the place of occurrence, then, my lord.
Caesar witnesses have supported.
Yes. Last portion, my lord, in statement of.
Lordship, as per Caesar list, only mobile phone recovered, Lordship. Nothing has been recovered.
No, vehicle also.
Vehicle also, Lordship, but no suspected material, Lordship, as alleged by the
Other
informant.
Baleno vehicle escaped.
Pliers, clamps.
That is the other vehicle, maybe, Lordship.
I don't know. Part 483 bill application by Hata Sariali PS case number 250 of 2025. By petition. They were arrested on 17/10/2025. The allegations in the FIR dated 16/10/2025 was by was that on 15/10 in the late hours of night, past midnight, in the late hours past midnight, on vehicle 801 PC 0673, 5 number of youths, along with another Baleno vehicle, illegally entered their house, assaulted him and his wife, and by threatening them with sharp weapons, committed dacoity and looted cash of rupees 80,000 and cattle. So, upon raising hue and cry, the local people chased the vehicles and they were apprehended. It is alleged that this since last 1 year, 150 numbers of cattle and goats, more than 150 numbers of cattle and goats have been stolen from this area. The case diary has been received. It is submitted by the learned additional people that the petitioners were caught red-handed along with the recovery of vehicles and mobile phones. I perused the case diary, and the seizure includes iron chisel, water pump pliers, clamp, etc. Which bears some correlation with the allegations regarding attempt to commit dacoity. Regarding attempt to commit dacoity, commission of dacoity. Commission of dacoity. Communicated that the Caesar witnesses have also been considering the police is looking into the involvement of a wider network. Investigation is in progress. At this stage, the bill still stands return the case.
My lord, in this case, not only attempt, my lord, they have committed, in fact, committed the
Committed. Disposed of.
May it please your lordship. Lordship, in this case, updated CD was called for, my lord. Updated CD not received, my lord. I'm on interim, my lord. That may be continued.
Long time, August. Since pending since August.
Yes, my lord. No, my lord. Case- one
Updated
minute,
case
yes.
diary is not yet received.
One CD came, my lord.
Issue reminder, yes, it came out. Issue reminder for the same. The interim bail granted by the order dated 29/8 stands extended till the next date of listing. List on.
9-1, my lord.
We also have constraints and we are packed.
Diplo. Again, my lord, we have received the case diary, but no accused person his statement is not in the case diary. He was granted interim. I order dated 4/9/2025.
498A.
My lord.
Is it 498A? No. 3042.
3042.
What is that?
Snatching, your lordship snatching.
Huh? Snatching.
Very allegation of physical assault also, my lord.
No, information is my sister's own friend here. Now they are good, your lordship. They are staying together only. The conflict took place with the workplace of the informant, your.
But his statement is not, so he's recorded.
This statement is not available in the case diary, my lord. Whether he has appeared before the IO or not.
He appeared.
So there was the one of the my
He
lord,
appeared.
bail condition, my lord.
Actually, the IO was on training, your lordship. We went to a police station.
Last week of January, you fix it, huh?
My lord.
I'm sending it back.
Yes.
The case diary is available, but the statement of the petitioner, which is stated to have been recorded person to grant of interim, is not available. The case diary may be returned back and update and procured after update, procured after incorporating up-to-date investigation, including statement of the petition.
My lord.
Interim bail granted by order dated 4/9/2025 stands extended till the next date of listing.
29-1, my lord.
29.
Hello.
Please, your lordship. Lordship, this is the second bill application, your lordship. The earlier rejection order is on page 2021, your lordship. The, FIR, your lordship will find the FIR from page 13 to 19, your lordship. The incident occurred on 15/6/2025, your lordship.
8/9, quite some time back. See the investigation after 8/9.
Yes, my lord. The investigation, my lord, it is pending for my lord to arrest these accused person, my lord. And lordship may kindly say what is their new ground, my lord. Kindly, lordship may kindly come to page number, paragraph number 7 of their bail application.
7.
7, my lord.
Progress of investigation can be a subsequent ground. Also, but in this case,
Now, otherwise, my lord, the investigation has progressed, but because this accused person, my lord, they are the main accused person, my lord. And considering the earlier, my lord, considering the materials available in the case diary.
main accused
Lordship, yes, my lordship has rejected their bail application earlier, my lord. Now, this is the subsequent bail application, my lord. There has to be some new ground. That is, my lord, after 8/9, my lord. That has to be occurred after 8/9/2025.
Lordship, we are ready to cooperate with the investigation, your lordship. We are ready to cooperate and we will provide all the assistance to the investigating agency, your lordship.
what was the allegation?
Lordship, your lordship, this is a family land dispute, your lordship, which resulted in a fight between two parties, your lordship. Thereafter, your lordship, uh, it has been alleged that the victims were severely injured, your lordship, as a result of the assault. There were also some allegations of outraging of the modesty, your lordship, of women, your lordship. So this is a fight between two, and the informant clearly says that the petitioners are the brothers and nephews of her husband. So this is regarding a land dispute between two brothers, which ended in a clash between the two families, your lordship.
May I take your lordship to page number 22, man? The earlier rejection order.
Please have seen
Yes, page number 22, paragraph 5 and 6.
paragraph 5.
5 and 6.
Correct. Anyway, so
Now, my lord, this is subsequent bail application. My lord, there has to be new grounds, my lord, and that has to be occurred after 8-9.
Archie, very good. To order page 20. Three, same. This is 21. This is subsequent bail application as an earlier bail petition was rejected by this court on 8/9/25 in AB 1760 of 2020. It is submitted by the learned counsel that since the date of last rejection, the investigation must have progressed, and therefore the court may consider taking a fresh view in their favor in this subsequent petition. Case diary is received. The learned Mr. Borua, learned additional people, submits that there are no sufficient new grounds, and police is seeking to steadily examine the accused persons as they are stated to be the main accused in this case. Can I have a look at the diary?
Yes.
Another issue, your lordship, the police have never tried to arrest them in the meantime, or have called them in the station.
Necessary, but
clear from the case diary.
subsequent bail application. So I also have
Lordship.
my mandate is also limited, so let's have a look myself. Last date, 8/9. System. Bail objection has been submitted.
Hello?
Bail objection has been submitted.
Bail objection, my lord, in the note of the investigation observer, my lord, that is fine.
I saw something like. It's revealed from the to-date materials in the case diary about finding the investigation finding sufficient materials against the petitioner and repeated house searches have been unsuccessful. In the given facts and circumstances, I do not find sufficient new grounds to take a different view in favor of the accused in this subsequent petition, which accordingly stands rejected. Return back the case.
Well,
May I please, your lordship, this is clear as bail application.
Charge sheet submitted.
Charge sheet has been submitted.
Oh, interim, interim.
Yes, I am on interim, lordship.
108.
Lordship, as the LS section is session tribunal, kindly,
Sec-
lordship may kindly make an observation
Yes,
that the concerned court allow the petitioner to go on bail. Lord.
No, no, as you know, direction for giving bail cannot be given, but
Committal
can
court
just
court
direct-
cannot grant them anticipatory bail. Committal court cannot grant them anticipatory bail.
not, it's true. L is suicide, right? L is suicide. Yes, there'll be. Diary has come.
No, my lord, charge sheet submitted.
Charge sheet. Oh, okay. I had order dated 31/10/2023. The petitioner was granted interim clearance bail. Post. It is submitted by the learned prosecution today that in the meantime, upon completion of investigation, charge sheet has been filed against the against only the petitioner,
Yes, my lord, only
Not-
the petitioner.
sending him up for trial. In view of the completion of investigation, despite the nature of allegations, I do not deem it necessary to cancel the interim bail, which accordingly is made absolute. Semicolon. Subject, however, to the following conditions. He shall be available for trial. Which one commences? Number 2, he shall not hamper or temporary evidence, shall not try to intimidate or influence witnesses, like a standard violation of bail conditions.
35.
Article number to लिखी लोगों.
Yes, number.
Article number 121/2025. Dated 17/11/2020.
If you have the section, give that also.
The section is not mentioned in the mother.
You can give perhaps you can give a direction to the IOs.
Yes,
when
no, we have
charge sheet
given
is
my lord,
there,
but my lord, while sending my lord
they
information,
can give us
they have
one,
not mentioned
one more thing has to be written. It helps. And regarding report,
my lord.
the key section does better. That is, we need that. Boripur case. Yeah. Next.
Item number 35, my lord, case that is not received today.
35. Interim is there?
No, lordship,
there.
this is the second occasion CD has not been received.
The allegation of homicide.
Case of murder, my lord, so case that will be required.
Case diary is necessary. No, case diary will be necessary. Many cases also. But scope of the case diary is not received to the learned counsel submits, petitioner counsel submits that 2 dates have already elapsed. Issue reminder for the case diary. List on
9/1.
9/1. Quite moving.
Well, here is bail application, my lord, and your lordship find the FIR, my lord, separately, my lord, since at the time of filing of the bail application, FIR wasn't registered. So subsequently, my lord, FIR was registered and that was placed on the previous date, my lord. Your lordship will find the bottom of the. Well, this is a purely civil dispute, my lord, was given the color of a criminal offense by the police and registered the FIR. Initially, my lord, the lordship will find the there are 2 FIRs, my lord. One is from our side also. My mother lost one FIR and the Nunmati PS case number 198, this is the FIR where I'm seeking bail, my lord. Here the allegation is that, my lord, lordship, what happened? A sale agreement was executed between the petitioner and the informant, my lord. And as per the allegation, my lord, out of 55 lakh rupees, 54 lakh was paid. And he was pressurizing the petitioner to hand over the position, but the position was not given. That is the substance of the allegation, my lord. And here, as per the, as per instruction of my petitioner, my lord, out of 55 lakh, only 6,50,000 only paid. Only 6,50,000 was paid out of 55 lakhs. Your lord will find in my petition the particular annexure 1, my lord. The annexure 1 is the agreement. It is a sale agreement, my lord, between the petitioner and the informant. Lordship will find page number 13, my lord.
Page number 13.
13, my lord. No, not 13. I'm sorry, my lord. Page number 14, my lord. 14, my lord. Page 14. That till today the purchaser second party has paid an amount of rupees. This is a blank portion, my lord. This portion has been kept blank, my lord. Initially, what happened at the time of agreement, my lord, the informant was supposed to pay 10 lakh rupees at the advance amount, but he paid only 5 lakh rupees. Out of 5 lakh, 2 lakh was paid in check and 3 lakh was in cash, my lord. That I have given the statement in my petition. Now, what happened? Subsequently, again, 1,50,000 was paid, my lord. Even assuming that, my lord, total, my lord, 6,50,000 was paid. Even assuming that, my lord, the allegation of the informant are correct, that he paid 54 lakh rupees, he can approach the civil court, my lord, seeking a exclusive performance contract. How the criminal offense comes in here, my lord? So, my lord, on the previous judgment concerning the nature of the allegation, my lord, already the honorable court granted me in the interim protection, my lord. Even, my lord, prior to registration of this FIR, my lord, I went to police station twice, my lord. My statement was recorded by the IO, my lord, and I executed one PR bond also. So only, in fact, I was informed by the police that this is a civil assault of dispute, so the police will not do anything. But subsequently, my lord, I went to Bangalore for treatment of my wife, and during my stay at Bangalore, my lord, police repeatedly went to my house, my lord, to search me out, my lord. Then only, my lord, I had to prefer this bail application, and during pendency of this bail application, the FIR was registered. Interim. This FIR was lodged, my lord, on 18th of October and registered on 8th of November, my lord, after almost 20 days, more than 20 days, my lord. Still, considering the, my lord, nature of allegation, and since I'm on interim protection, so that interim protection may be made absolute.
See, there's an allegation. He said contention is that it's a civil dispute. Yeah. Look, on the face of it, it is a civil dispute. But this allegation, suppose if it is true, if that he has taken money for sale of land from different person, then it indicates dishonest intention from the inception. Because I cannot sell the same land to two persons.
So I want to.
So investigation, what has it?
Lordship, I also going to take that point only, Lordship. Otherwise, consideration what he has taken, I am not on that, Lordship. Regarding that part, I have two things only, Lordship. In the complainant statement, Lordship, he has stated that he came to know. Later on, I got to know that he is a fraud and he has taken money in cash from several persons and do not return it back in his statement. And within that period, Lordship, no other witnesses. There is a witnesses that he has given money or that of like that, Lordship. However, in the IO note, he has only stated that, Lordship, after inquiry, I found that he has taken money from several people in the same trap. But he has not, witnesses are not there, Lordship. Yeah. I only want to point out that only, Lordship. So the complainant has stated thing, and in the IO note he has stated, but I have not reflected, witness has not been there, Lord. What inquiry he has made, I have no.
So Anika Das has been struck off, right?
Mr. Gopal.
Otherwise, his statement is there, Lord.
If it's a fraudulent activity on for multiple persons, then certainly
there would be
not deserving of anticipatory bail.
So,
If that is true.
my lord, one more submission, my lord. Only the FIR was lost by one person only. If I took money from several persons did not lose the FIR. Firstly, secondly, my lord, your lord should find the money received. That money received was
Or we can allow the investigation to continue for some more time. Keep it pending.
We may be directed to update, Lord. That may be.
Yes, that is a point in your favor. He said that he's correct. He can take that contention. That if I have cheated other people, others should also have filed cases.
Lordship, that is why I am also.
That is a valid point. Anyway, let the investigation progress. Instead of taking a view this way or that way at this time. Let him remain on entry. The case diary is received, and though the complainant has supported his allegations in the FIR, There's also a noting in the case diary about the petitioner taking money in similar lines from other people. But learned additional people has fairly submitted that we did not notice statements of witnesses on those lines. Nevertheless, the case diary may be returned back and cured again after some more investigation. The interim bail granted to
In
the
fact, my lord, I'll make one more point at this stage, my lord. After this FIR, my lord, how this informant got the authority, my lord, to enter into my premises and to assault my mother, mother and sister, my lord,
have you
with a gang,
lost
my
that
lord,
FIR?
with a gang of many persons, they entered into my premises, assaulted my mother and sisters.
Have you taken recourse to law?
Yes, my lord. I lost the FIR. That FIR is also there, my lord.
So many cases.
My mother lost the FIR, my lord.
Multiple cases fighting each other. All kinds of things are happening now.
FIR, Nunmani case 201, that is the FIR lodged by my mother, my lord. There is a photograph also, my lord.
Nobody should take law into the hands.
Yes, my lord. How can he enter with a gang of Gundabani? He entered into my premises, my lord.
My point is that the criminal justice system come on the
Lordship will find, my lord.
with regard to this matter, the criminal justice system
But
should
even
actively discourage this kind of dangerous fraudulent activities because people spend their life savings on purchasing a land. Suppose if they do fraud, it is so. Therefore, okay, interim I will be continued. You fix it in the last week of January. By that time, probably investigation will be complete. He will not be prejudiced. He may not be prejudiced, but suppose there are materials because granting bail means towards the entire trial. So that has to be seen. Oh, after Bihu, you can fix third week. Interim bail, yeah, no, that's okay. He has no right. Yeah, he can. Everybody has to take recourse to law. Otherwise, you forget. We'll have anarchy. So if he has barged into your house and beaten you, that's not right. Certainly not. That is also a illegal activity.
On 29 January.
Or you can fix it in third week also. If you
Lordship.
think end of third week. End of third week. The
Then
interim
that will
bail
be-
stands extended in the last date of listing.
22 Lordship.
Send the diary, procure again.
22 Lordship.
The okay, 22-1.
22-1. All right.
এটা থাকিল নহয়, তেতিয়াহ'লে।
All right, my lord.
তেনে হেৰি কৰি দিম। Okay. We'll take that. Two. Question. Yes. Yes.
We're extremely sorry, my lord. With regard to that item, I mentioned in the morning, my lord,
Yes.
item 15.
No problem.
But can it be fixed on 20th with the consent of both the sides?
Okay. Oh, no, it can be, but I'm just.
Though it was fixed on
I
5th,
forgot
only.
actually. What was the matter?
Item 15, my lord. The quashing petition.
Oh, what's that? Mentioned. Okay. You had mentioned in the morning.
In the morning, I
You want change of date.
only the change of date.
When
20th.
when do you want it?
20th Jan.
Oh, it's that one.
20.
Okay. So, but how do we now today? Praise for listing the matter on 20th January. What will happen on 5th? Will it come again?
No, Lordship,
Not
instead of 5th, Lordship, it is
Instead of 5th, it will be listed on 20th on prayer of learned councils for both the sides, seeking some accommodation instead of this thing fixed on 20th January. No problem.
Deeply.
I had forgotten actually. 20 this time.
37.
Yes. 37 matter.
37 and 40 arise out of the same
Same.
FIR, Lordship. And in both the cases, in interim is there, Lordship, and we have not received CD, Lordship.
We extend it.
Yes, your
37 is the order of case diary is not yet received. This is same FIR.
Same FIR, Lordship.
Yes.
This case is the same, Lordship.
Case diary is not yet received. Issue reminder for the same. The interim bill granted by the order dated ... shall stand extended till the next date of list. 37 and 40.
40, Lordship.
Same order.
On 28, Lordship, 28-1.
28-1.
Deeply. Interim continue.
Yes, interim bail granted. I have said.
Yes.
I've al-
May I please, your lordship? My lord, the pre-arrest bail application, my lord. FIR page 8, my lord. My lord, I prayed, my lord. She is on interim, my lord. That may be kindly be, my lord, absolute, my lord, because she having a 1 year, 1.5 year old child, my lord.
Hmm.
I have annexed the birth certificate also, my lord. And the allegation, my lord, absolutely, my lord, concocted, my lord. They are sharing the same boundary wall, my lord, immediate neighbor, my lord.
Anyway, charge sheet submit.
Yes, my lord.
Itu- available. Para 23123, it's same. Petitioner was granted interim bail on the right order dated 13/11/25. And today speaks for case diary. Full stop. However, the learned additional PP submits that in the meantime, upon completion of investigation, charge sheet has been filed.
Charge sheet number
Like CS number
90/25 dated 28/11/25.
The given facts and in the view of the completion of investigation, the interim bail is hereby made absent, subject to the condition. Petitioner shall be available for trial if on commencement, so it shall not hamper or tamper. The petition stands allowed and disposed.
Obliged, my lord.
May I please, your lordship? In this case, after getting interim, my lord, the petitioner appeared before the IO and recorded his statement, my lord.
But it is
My
not
lord.
updated, lord. It is updated up to lordship
No, my lord, it is just
20/11.
on the last week, lordship has granted interim, my lord. And on Wednesday, my lord, he has recorded his statement, my lord.
But it is not in the CD lordship because it is last entry is 20/11. And
His statement is there,
no, lord.
not there. It will be necessary.
You need to be up to date, lord. Then
needs to
only
be
you
up-
can get a.
It needs to be up to date. He is appeared according to.
Yes,
He
my lord.
appeared.
Yes, yes.
Or not reflect. Anyway, so the case diary is received, but this state, it is submitted to be not sufficiently updated. And the statement of the petitioner purportedly recorded after grant of interim is also not available. The case diary will be returned back and procured again with up-to-date investigation, including the statement of the petitioner. The interim bill granted shall stand extended to the next date of listing. List the matter on
28/1.
28/1.
Lordship.
42.
May please, my lords. This is a anticipated bill application, which has been filed for a second time. Perhaps my lords remember the extensive hearing which had held. Mr. V.K. Mahajan was opposing. My lord, this is with respect to the second accused in the prior set of litigation, my lord.
Just a minute.
Yes.
That's, this is mentioned about 41. Huh? Hmm? 42, 42. Two members. It's not saying, no? The AB hearing is not there. Just a minute, sorry.
Of course, ma'am.
Yes, for Mr. Bora.
My lords, by way of a background of the petitioner, my lord, if my lord peruses page number 30, there's a no objection certificate by the District Council of Karbi Anglong. He is, my lord, essentially a trader. He runs a piggery distribution market by the name of Measures E. Tiso, my lord. And that market is located in the AK Market, Lahorijan. Now, my lord, this AK Market is owned by the accused number 1 in the prior set of litigation, my lord, Augustine Kramsa. So that is how this petitioner is related to the main accused in the FIR, my lord. Apart from that, there is no such links.
Now, if my lord comes to the FIR, it begins at page number 16. And this FIR essentially, my lord, deals with the incidence of honey trapping. And if my lord looks at the allegations under which the FIR has been registered, my lords, the first and the most important, perhaps, allegation is of extortion, my lord. Under section 308, clause 5. It, my lord, talks about extortion by putting a person in fear of death or grievous hurt. And my lord, this carries a maximum imprisonment up to 10 years or fine. And my lord, for the same, the period of investigation is 60 days. And my lords, with regards to that, the further allegations are of criminal intimidation under 351 subclause 3, which is a bailable offense, my lord. And then 61(2) talks about criminal conspiracy. Again, it's a bailable offense. And my lord, 67 capital of the IT Act, which comprises of an imprisonment up to 5 years, my lord.
So,
It
Mr.
talk-
Bhua, can we go to the subsequent grounds?
Yes.
Since it's a new application.
Yes, ma'am.
With regard to, because I will not be able to.
My lords, my contention
Law
here
will
in this.
not be able to go over it, the merit again. to
Yes,
that
ma'am.
extent.
Yes,
And subsequent grounds and the subsequent investigation.
Yes, my lords. Perhaps my learned friend would be
Yes,
able to point out the progress.
Just submit, if necessary, we'll come back to some.
Of course, my
extent to
lord.
The merits.
My lords, if I may take your lordships to the FIR at page 17.
Yes.
My whole ground is that, my lord, in the previous rounds, perhaps the peculiar facts pertaining to a petitioner could not be properly put before my lords on my account, my lord. That is why I have filed this to bring it to the specific notice, the allegations per se, my client, my lords. If my lords comes to page number 17, my lord, I'll only be going through the specific attributions. If I may read, my lord, from page 17. The fourth line, my lord, from top, starts from thereafter.
I'll go through it.
Yes.
But I will my own order, so I'll just.
Yes, my lord.
Para 17, you want to make?
Page number 17, my lord, of the FIR, my lord.
Oh, FIR, so
Yes,
you can
my
read FIR.
I just wish to highlight the facts pertaining to me, the allegations against me.
Para 2.
My page number 17, my lord, from the top, the fourth line, my lord, thereafter. That para, my lord, and the subsequent para. My lord, if my lord reads through these paras, it is evident that the main allegation of extortion and criminal intimidation is on account of Augustine Kramsa, my lord. It has been specifically pointed out that it was Mr. Kramsa who had demanded money, and if the money is not paid, then he was put in fear of injury to his reputation by placing the videograph in question in the public domain, and he was also put in fear of death, as a result of which 30 lakhs were extorted. That is the specific allegation in the first pair of page 17, my lord, in the FIR. Then subsequently, the lady was implicated for honey trapping. And then, my lord, the fifth line in the second para of page 17, it reads, at the instance of Augustine, and upon threats subsequently by the lady so-and-so, my father also paid rupees 28 lakhs in total in 3 installments out of fear, so that the videograph in question was not to come into public domain in the matter as threatened. Then, my lord, comes to the next paragraph. Then suddenly, my lord, my role appears. It says it is reiterated that under the circumstances, all 4 accused persons named so above criminally conspired to extort the amount quoted above under threat of physical annihilation at different points of time. Now, my lord, for the criminal offense of criminal intimidation or criminal conspiracy to be made out, the basic ingredient should be there that I was also complicit in making the threat of extortion, my lord. From the reading of the aforesaid paragraph, my lord, there is no such ingredients against me. I have just been brought in by way of an annexure, my lord, in this whole case. Otherwise, there is no involvement on my part. And so far, the allegation of transmission of that video is concerned, my lord, there is nothing to say that I had transmitted it, my lord. Therefore, these are primary ingredients which are missing, my lord. And my lord, I do not have any criminal background, as was portrayed in the last round of litigation, and that is true in the case of the main accused, my lord. But I have a very clean slate, my lord. I do not have any allegations against me. It is the first time I have been roped in an FIR, my lord. And my lord, I am a family man, my lord. I have a wife who is pregnant. She is due to deliver in the month of January, my lord. Oh, my lord, I pray that it may be considered, my case for liberty may be considered. And my lord, a co-accused, my lord, Peter Tissot, he was named in the FIR. He has recently been released on bail, my lord, but of course that is default bail, my lord. I'll have to submit fairly on that, my lord. And so far, my lord, the allegations on the previous round from what I could make out, my lord, the
He's
co-accused,
hero, no?
my lord,
His name is,
uh,
petitioner's name is?
my client's name is Enjoy Tissue, my lord. Enjoy Tissue.
So,
Yes.
enjoy this.
Yes, my lord. And my lord, on the last occasion, from the perusal of my lord's order, I could find out that the co-accused, the lady, had named me, my lord. On that point, my lord, the law is very clearly laid down, my lord, in a very recent judgment, my lord. If I could kindly
I
point
cannot go
out to that.
I cannot go on appeal against my. I may be
Of
wrong.
course, it is my duty, my lord,
I have
to just
to-
point
but
it
I
out,
will-
my lord.
We'll see this aspect. When is his wife is due for delivery in January, you said?
Yes, my lords. I have annexed certain documents. The due date is not visible there, my lord, but the reports are there, my
No,
lord.
man. So,
If I can take my lords to page number 36, my lord, the very last page. My lord has that report.
yes, I've seen that.
My lord, under the heading provisional diagnosis, my lord. It's the third column, perhaps.
Yes, sir.
There is a written line, my lord, early pregnancy. There's some G3P2C2 at early pregnancy. And
Medical
this,
terms with-
my lord, was issued on 24/6/2025. Down below is the date, my lord. My lord, the due date, as per my instructions, is in the month of January, my lord.
No issue.
Therefore, my lord, he is the sole earning member of the family and sole caretaker, my lord. And because, considering his clear background, my lord, the case for anticipatory bail may kindly be considered. And my lord, the co-accused statement implicating me, my lord, at the stage of bail cannot be considered in my humble opinion, my lord. And I am supported by the Honorable Apex Court's judgment in Pre Krishna Mohan Reddy. My lord is aware of it. It's 2025 INSC 725, my
I
lord.
can see it. I can see it again.
Yes, my lord. May I produce a copy, my lord?
Yes, yes.
Yes.
Like to see it.
May I draw my lord's kind attention to para number 53, my lord. It would be in running page 27. Down below is the page number, my lord. Page number 27, para 53. The operative portion.
Para 23, right?
Para 53, my lord.
53, yes.
At page 27.
Yes.
My lord, may kindly come to the next page. Point number 4. There's sub point 4, my lords. On the very next page, page 28. My lord has the page.
Yes.
May I read, my lord? Where such police statement of an accused is confessional statement, the rigor of section
sir,
25 and 26 respectively will apply.
Para 53.
Yes, my lord. Para
Okay,
53, sub para 4, my lord.
Four.
Yes, at page 28, my lord says it. It begins from where such police statement of an accused. Where such police statement of an accused is confessional statement, the rigors of section 25 and 26 respectively will apply in all its vigor. A confessional statement of an accused will only be admissible if it is not hit by sections 24 or 25 respectively and is in tune with the provisions of section 26, 28, 29 of the Evidence Act respectively. In other words, a police statement of an accused which is in the form of a confession is per se inadmissible, and no reliance whatsoever can be placed on such statements either at the stage of bail or during trial. Since such a confessional statements are rendered inadmissible by virtue of section 25 of the Evidence Act, the provision of section 30 would be of no avail, and no reliance can be placed on such confessional statement of an accused to implicate another co-accused. Then, my lords, may I kindly draw my lord's attention to point number 9 at page 30, my lord.
Just a minute. Huh?
Yes, ma'am.
Yes. That's
My lords, may I draw my lord's attention to page number 29, point number 8. My lord has the
point number.
Point number 8, my lord. May I read, my lord? Where the police statement of an accused is an exculpatory statement, that is, it is neither a confession nor an admission, The statement being one under section 161 would immediately attract the bar under section 162 of the CRPC, and the same may be used only for the limited purpose provided in the proviso for the purpose of contradiction or re-examination of such accused person alone, as held in Mahavir Mandal. Then, my lord, the next para 9. It reads, although a handful of decisions of this court, such as Indresh Kumar and Salim Khan, have held that statements under section 161 of CRPC ought to be looked into by the courts at the stage of anticipatory or regular bail for the purpose of ascertaining whether a prima facie case has been made out against the accused and the nature and gravity of the allegations, yet the aforesaid rule only applies insofar as such statements under 161 were made by witnesses and not accused persons. A statement of an accused under 161 of the CRPC stands on a completely different footing from a police statement of a witness. My lord, this is what I'm praying for. That my case against me may not be held on the basis of my co-accused.
Very good, Jalal. I don't remember reading this 53 section.
Yes,
Anyway, thank you for giving me this.
And my lords, there is one more judgment I'd like to point out. It's on a very small point,
very important.
nevertheless.
It's a good judgment. Just point important principles. Delivered on which day? The recent one. 16 May 2025.
Yes. Well, it is just one more judgment on a very small point, my lord. Just to indicate one thing. My lord, this is the landmark case of Rakesh Kumar Paul arising out of our own High Court. If I may draw my lord's attention to para number 65 at page number 107, my lord. My lord, this judgment, while dealing with that 60 days and 90 days period, also looked into the intention of 167. If my lord has 65 para, I may read.
I'm on 65.
Yes. Keeping in view the legislative history of section 167, it is clear that the legislature was carving out the more serious offences and giving the investigating agencies another 30 days to complete the investigation before the accused became entitled to the grant of default bail. It categorizes these offences in 3 classes. The first category comprises of those offences where the maximum punishment was death. Second category comprises of those offences where the maximum punishment is life imprisonment. Third category comprises of those offences which are punishable with a term of not less than 10 years. In my case, my lords, the maximum punishment that can be levied is up to 10 years, my lords. That is under the extortion section. And the Honorable Supreme Court specifically observed that only for more serious offences, the investigation period of 90 days have been prescribed. So, to the extent that my allegations do not fall under the 90 days bracket, my lord, it cannot be termed as a serious offence for the purpose of consideration of bail. That is another point that I want to impress upon my lords. And considering all these facts, my lords, I pray that
one point of view. That is one point of view.
Yes, my lords. So that is all that I submit, my lord, on this point. Subject to what my senior has to say.
Heinous offence. I mean, it has different.
It has clearly been categorized, my lords, and my case does not fall under serious offence.
Well, in terms of vis-a-vis statutory bail.
Yes, ma'am.
That you can say.
Yes, that is what I have to say.
My lord, here, my lord, that is earlier, my lord, this PRS bail application was rejected on 24/10/2025, my lord.
Yes.
And my lord, categorically, my lord, that is my lord, in that order, my lord, everything is my lord described when my lord was pleased to reject the my lord.
This was
bail
in,
prayer.
what was the date of
Now,
last
my
one?
lord, that is my lord 24/10/2025, my lord. That is the rejection date, my lord. It is my lord the annexed as annexed, my lord. It is in page 19, my lord. It is annexed, my lord. And my lord, from that is the
So whatever it is, rightly or wrongly, I passed that order.
yes,
Whatever I
ma'am.
thought was
Yes,
correct at that
and my lord, from paragraph 12, my lord, it is very clearly, my lord, along with all the my lord, the authorities relied upon by the my lord informant. Everything is elaborately, my lord.
He has also
discussed,
placed.
and my lord was pleased to reject. So, my lord, I am not taking so much time of your lordship. So, my lord, after 24/10/2025, the new ground in this petition, what I found is that only the pregnancy of the my lord, that is the wife of the accused. That is whether my lord, this is a ground for a second bail application or not. This I leave it to your lordship, my lord. Now, my lord, apart
if a delivery is due,
My-
Sometimes it can be,
My,
sometimes it can. be.
only that is, my lord. Other than
In
that,
a
my lord, there is.
general sense, whether,
Yes, yes, my lord.
some,
Now, my lord, it is
it
a
is
case
a,
of.
whether, there are, it can be a ground generally also in
My-
bail, but thing is that, whether there are other factors which will,
Yes,
if-
my lord.
which can even prevail over such a thing,
Yes,
that,
my
that will depend on facts.
Yes, ma'am. Now, my lord, after my lord, that is my lord, that is this rejection order, my lord. They tried to, my lord, search them, my lord. One, my lord, that is who was a militant, my lord. He was, my lord. They went for, my lord, to Delhi to search them, and his statement recorded. And thereafter, from
He's
Delhi,
arrested.
yes, my lord. My lord, he was, my lord, admitted that point of time. So he was like a, my lord, there is a, in the hospital, they arrested like this way. And my lord, in the race part, my lord, they are searching this person. Now, my lord, here I am not, my lord, going to the, my lord, that is the statements of the accused, my lord. But here the thing is that it is a monetary transaction was there. There was a video, my lord, and the statement of that victim and the complainant, my lord, which implicated. And as per their statement, the nexus along with this person is very much there with the another co-accused person. So that is before your lordship. I have flag mark, my lord. That is the victim statement, though my lord have already gone through that, my lord, and also the statement of the complainant and two notes, my lord, during the course of investigation. My lord, at this stage, my lord, it is not a, my lord, that is a, my lord, it will, my lord, affect the investigation if he will be granted bail. Because, my lord, allegation is very serious, my lord. Because after that trapping, my lord, that is 50 lakhs of transaction, and the person, those who are involved, they have other cases, my lord, and my lord, that part is different.
My lord, if I may quickly have a reply to that, my lord. My lord, my senior here submitted that the informant also had objected to my bail on the previous round. However, my lord, a perusal of the relevant paras at para 7, especially of the bail rejection order, my lord, it clearly reflects that those allegations per se or those submissions per se were against the main accused, my lords. The informant's learned counsel had not brought in anything adverse against me, my lords. That is, the informant had mainly focused on Augustine's criminal backgrounds, my lord, and that is where his entire argument set centered around. And my lord, even the learned PP had objected on the huge pendency of numerous matters. And my lord perhaps remembers that in one of the cases, he was also argued to have been a proclaimed offender. Considering all those overwhelming factors, my lord was pleased to reject the bail. But none of those factors are applicable in case of my client here, my lord. Therefore, that is another thing that my lords will perhaps consider while considering my case for bail, my lord. He is not a person who will abscond or who will not cooperate, my lord. He is a family man. He is due, his wife is due for pregnancy, and he has to take care of her. And while at the same time, he is willing and able to cooperate with the police whenever he is called upon, my lord. And I have already indicated, my lord, this does not fall under the heinous offenses category, since the investigation period has been classified as 60 days and not 90 days, and up to 10 years, my lord. And except extortion, my lord, all the other offenses are below 7 years, whereas Section 35 notice also suffices. My lord, there is no need to have him in custody in my humble submission, my lord. He can be served a notice, he can come, my lord. That is also there.
No one can do it, huh? So, next. Okay. Good submissions. Mr. Borua, learned counsel for the petitioner, submits that the main allegations in the case were against the co-accused Augustine Kramsa, full stop, and that any statements of co-accused made before the police would be barred to be taken into account, even for the purpose of adjudication of the bail. In support of his contention, the learned counsel relies upon a decision on the Honorable Supreme Court in the case of P. Krishna Mohan Reddy, 2025 versus State of Andhra Pradesh, 2025 in SC 725, drawing attention to para 53 drawing attention to the principles laid down in para 52. Referring to the case of Rakesh Paul versus State of Assam, 2017, 5 SCC 67, para 65. It is contended by the learned counsel that in terms of that categorization, the alleged offenses against the present petitioner should not fall in the category of serious offenses. Good stuff. It is also submitted, drawing attention to annex medical document. The learned counsel also submits that the wife of the petitioner is in advanced stage of pregnancy with due date being in January 2026. Good stop. Though he fairly states that the said document does not specifically clearly state the due date. Good stop. The updated case diary has been received. On the basis of the same, Mr. Boyso, the learned additional PP, submits that whether the aspect of pregnancy would constitute sufficient ground is left to be decided by the court. However, his involvement in the his involvement as his nexus with the prime accused and being involved along with him in the alleged offense of extortion through blackmail has been revealed by the investigation, and that revealed by the investigation. Good stop. It is submitted by the learned additional PP that allowing the subsequent bail petition would adversely affect the investigation. The submissions can come. So they did that.
Man is reserving the order. Is reserving the order, my lord.
Reserve, actually, I tried to deliver it today only.
I'm so obliged. my lord.
Order 3.
Made resolve order. My lord, it's an anticipated bail application, my lord. FIR is at page number 15. Basically, it's a case of matrimonial discord. The informant happens to be the father-in-law of the petition. So the petitioner had married the informant's daughter 2 years back. And because of some matrimonial dispute, she went to her house, parental house. Thereafter, my lord, if your lordship wants, I can read the FIR. Particular page number 15.
15.
Case is of grievous hurt and attempt to murder.
Yes. Shall we read it?
Yes.
Diary has been received.
Yeah.
Due respect.
সন্মানপূৰ্বক বিনীত নিবেদন এই যে মোৰ ছোৱালী মীৰা সেনক আজি প্ৰায় 2 বছৰমান আগত তলত নাম উল্লেখ কৰা পদকীয়াৰ লগত বিবাহ হয়। বিবাহৰ পিছৰে পৰা 1 নম্বৰ পদকীয়াই বাকী পদকীয়াৰ পৰা মতে মোৰ ছোৱালীক ওপৰত শাৰীৰিক আৰু মানসিক অত্যাচাৰ চলাই আছিলে। উপায় নাপাই মোৰ ছোৱালীয়ে 4 মাহ ধৰি মোৰ ঘৰত আশ্ৰয় লৈ আছে। যোৱা 1/10/2025 তাৰিখে দিনত ৰাতিপুৱা 4টামান বজাত 1 নম্বৰ পদকীয়া হাতত ধাৰাল ডেগাৰ লৈ আমাৰ ঘৰৰ পিছফালে লুকাই আছিলে। মোৰ পত্নী নতুন বালা ৰায় বয়স 40 বছৰ ঘৰৰ পৰা বাহিৰত ওলোৱাৰ লগে লগে পদকীয়াজনে মোৰ পত্নীক হত্যাৰ উদ্দেশ্যে পিছফালৰ পৰা ধাৰাল অস্ত্ৰেৰে ঘপিয়াই শৰীৰৰ বিভিন্ন অংশত গুৰুতৰ জখম কৰি পেলাই লৈ যায়। পিছত আমি গম পাই লগে লগে গাড়ীৰে ধুবুৰী DMCH লৈ চিকিৎসা কৰোঁ। So my instruction is that the petitioner went to take his wife from her parental house. So while she was coming, my lord, there was some kind of altercation between the petitioner and his in-laws, which resulted in this altercation.
So this allegation of attacking with weapons and all exaggerated?
Yes.
Your instruction?
Yes. She
Injury
wants to come to her matrimonial house, but her parents, they don't let her to come. So that's why, my
Yes,
lord,
he was, because according to the,
yes,
the
yes.
suffering cruelty.
Yes.
Anyway,
Lordship will examine the medical, like,
yes, medical, medical is there.
The victim statement, lordship, is there. And she has stated that from the backside, he will also cut this person. And moreover, lordship, the one CT scan is pending because she has stated that she has some injury on her brain. And moreover, I had something to state, lordship. It is true, lordship, injury report is there. And it is simple and blunt. But if photographs are also there, but it does not show that, lordship. So lordship may decide on own, lordship.
No, there's one grievous injury also. Fracture on the NECT of head, the parietal bone. Parietal bone, parietal. Grievous will blunt.
Otherwise, victim statement is also there, lord.
Photo indicates grievous injury. They have assaulted that day. Maybe.
my lord may also see one thing, if the attack was caused from the backside, whether she had sufficient scope to know the attacker who had caused the injury. And
Are there. Because bad injuries. Photographs are quite.
but otherwise, my lord, if it is simple and grievous injury caused by blunt weapon,
No,
then-
these photographs are the injury.
Yes,
skull.
That is why, lord.
Crack.
yes, but my lord will go by the opinion of the doctor.
No, one is a head injury. Which
By
is grievous.
blunt weapon.
Anyway,
That will be bailable perhaps, my lord.
will not be liable to grant bail. It's anticipatory bail.
Then my lord will kindly wait for the CT scan report then, my lord. After
Conduct
vacation, my
is
lord.
very bad, you know. At least conduct. Third, esophagus, lung cancer, and so on. Invoking 482 BNSS. The petitioner is seeking anticipatory bail in connection with Agomoni PS case number 144 or 25. Section 20. The fire has been lost by one Tanu Sen with the allegation that his daughter got married to the accused 2 years back, and then the petitioner along with other members of his family who have been arraigned as accused in the FIR have been inflicting physical and mental torture upon his daughter, on the informant's daughter, due to which she had to take refuge in the parental home. It is further alleged that on 1/10/25 early morning, the accused number 1/petitioner herein, hiding behind their house with a sharp dagger, and when the informant's wife went out, he suddenly stabbed her from behind, thus and caused severe injury. Stop. His wife, Nutul Balare. The case diary has been received. Learned additional PPS. Placed the case diary before the court. I've perused the medical report, which indicates simple injuries as well as grievous injury on the head, the / parietal bone by way of fracture. The IO has also annexed some photographs in the case diary. The statement of the victim is also available, in which she lends support to the allegations in the FIR, and it is revealed from her statement that her daughter was subjected to matrimonial cruelty and torture while she was in a matrimonial house, and even after she came back to the parental house, the petitioner used to keep coming there and quarrel and threaten with them. He has stated about the incident and inflicting of injuries. In the given facts and circumstances, this may not be an appropriate case for grant of anticipatory bail. Accordingly, the bail petition stands rejected. Return back the case to.
Well, it's posted. Highly obvious.
May I please, your lordship? This is for anticipatory bail application, lordship. Allegations are 303 subsection 2 and 317 subsection 2 of BNS, lordship. Lordship, kindly see the page number 13, which is FIR page, lordship. I'm reading the FIR. Lordship, I would like to report that on 8/10/25 at around 7 p.m. source information was received. Revealed that 2 trucks bearing registration number so and so were illegally parked at Brahmaputra Industrial Park, Gauripur, and the same contained illegal shipment of items suspected to be stolen and transported in a clandestine manner. Based in the input, team under OC of Changsari PS along with SI Hemkanta Sharma, accompanied by ASI Arshad Ali, and staff visited the spot. The vehicles were tracked but did not find the driver, handyman, etc. The trucks were inspected and checked and found hidden compartments on the roofs of the both trucks. During the search, the following items were found concealed inside the state compartments and accordingly seized. Number 1, 6 bags of whole areca nuts suspected to be Burmese, each weighing 80 kg. 181 bags of whole areca nuts suspected to be of Burmese, each weighing 50 kg, and 87 bags of sliced areca nuts suspected to be Burmese, each weighing 70 kg. The trucks bearing registration number so and so were also seized. Lordship, this in this case, we are the owner of the vehicle, lordship. I'm praying for 2 vehicle of the owner, and lordship, we are not aware about the booking and shifting of the articles, lordship. Lordship, even we are not the FIR based accused. We are just the owner of the vehicle. Lordship, in this case, the investigations agency imposed section 303 subsection 2 and 317 subsection 2 of BNS, lordship. Lordship, 303 defines theft, but theft if something was possessed or moves without permission or consent of the owner. Lordship, in this case, no one has claimed ownership of the seized articles, lordship. Lordship, police themselves registered this case against us, and this is our only involvement is that we are the owner of the.
Yes, okay. That's.
Lordship, CD has been received, and after going through the
CD Lordship, it has sufficient materials has exist against the present petitioner's Lordship.
Also,
Yes, Lordship, although they are the owners of the vehicles, so on a secret information by the police personnel, they have intercepted the two vehicles which were loaded with some suspected articles.
Erica nuts.
Erica nuts, Lordship. After that, Lordship, they have charged the vehicles and getting, Lordship, 6 bags of whole Erica nuts, which suspected to be Burmese. Its weight 80 kg. Then again 181 bags of whole Erica nuts, which is also suspected to be Burmese supery. Its weight 50 kg each, Lordship. And 87 bags of sliced Erica nuts, each weight 70 kg, were found concealed inside the secret chamber of the trucks. So all these things, Lordship, Lordship, kindly go through the seriousness and gravity of the offense, which Lordship used.
The driver
amnesty-
handyman have not been found.
They have fled away from the spot, Lordship. And it was found to be abandoned in a road. And truck owner, they have failed to produce the required documents, and they have failed to produce the same, Lordship.
Lordship, we have
And
appeared
the
before.
conduct of the vehicle owners, that they have used secret chambers inside the truck.
Secret chamber.
Yeah. Lordship, there is a high risk of tampering and everything. You can say, I'm just giving the.
Lordship, this is the allegation, and actually we are not aware about the incident. We are just the owner of the vehicle, Lordship. And we all and we appeared before
Initially,
the
they were
IO.
interim bail was granted by the trial court. And later on, that has been rejected, Lordship. And after that, Lordship, the investigating officer has given the bail objection period. Lordship, kindly go through the bullet points.
Have it. Sit. You can sit.
Lordship.
Have a seat.
All right.
What is this? Yes. That's hard for hard. And additional with SH for invoking 482 BNSS, the two petitioners here, namely so and so, are seeking pre-anticipatory bail in connection with Sangsari PS case number 201 of 25 under section 1. Good stuff. The case arose out of FIR dated 10/10/2025. The gist of the allegations were that 2 trucks bearing registration number TRO, page 12, so and so, were found parked near Brahmaputra Industrial Park, Gauripur, and upon search, suspected Areca nuts of believed to be of Burmese origin and in large quantities were found and hidden compartments in the roofs of both the trucks. It is alleged that these are stolen materials and were being transported illegally. Stuff. The Learned Petitioner Council submits that the petitioners are innocent and not involved in any such illegal transshipment, and that they only happen to be the owners of the trucks. They are not aware of the going ons, any such going on. The learned additional people. Mrs. Bora submits that the investigation, however, belies such contentions in as much as the investigation has revealed that these were being transshipped illegally as per the illegally in secret compartments, and the investigation may, and that the investigating materials also indicate the complicity of the present petitioners as owners of the vehicles. So it is contended that the police investigation also confirmed that the driver and handyman of the trucks have been absconding as they fled away from the place of occurrence. The prosecution objects to the grant of bail. The IO has also submitted a bail objection, making several contentions, indicating that no documents have been able to be shown, and granting of bail at this stage would prejudice investigation, and that these kind of offenses are being executed in a well-planned manner by organized syndicates. In the given facts and circumstances, the contentions raised by the prosecution would be worth pondering, and therefore the instant bail petition for anticipatory bail, once rejected at this stage, return back the case diary. No, সেইটো দি দিয়া এইটো দি দিয়া দুটা বজাত আছে ন কোনটো আছে আছে correct. Only reply. Quickly make the reply. Admission from time permits. Complete your reply. 15 minutes.
Lordship. Lordship, this is a petition under 439(2), and I have not invoked the inherent extraordinary discretionary powers under 482 or 226 of the Constitution for cancelling this bail. The primary ground for seeking cancellation of this bail granted by this Honorable Court is fraud on court. In IS 799 and IS 665, both the bails were granted from a single FIR, Dibrugarh PS case number 442 of 18, pending since 2018 till date. Though the grounds are similar raised by the other side in both the cases, a little bit of difference is there, Lordship. In 665, my locus has been challenged. My email to the registry calling for expeditious listing of the case. Thirdly, the accused has stated that silence is his constitutional right. And fourthly, I have been named as a FIR activist. The other grounds are bar under 362, authorities under Abdul Bashid, prolonged investigation, cannot be revisited by this Honorable Court again, and no change in circumstances. Lordship, before I answer to all these questions that are put up, IS 799, the bail petition 2355 was preferred by a person whose name neither matches with the person in the FIR
nor the name matches with the affidavit in opposition filed by him now. Secondly, he suppressed section 323. He came up with a defense that it is a bailable section. Lordship, 294 and 506 are also bailable. He should have omitted them also. He cannot be selective. He cannot be offered the luxury of being selective. Thirdly, Lordship, I pointed out, I will put up all the orders of this court. That a non-existent order was made absolute. Lordship can kindly allow me.
No, you told me, submit it.
Lordship can kindly. It should be. If my lords come to the first. Now, my lords, the first order was passed on 25/7/19, an interim was granted. The second order, 38/19, the same interim was extended. And on the third day, that is 23/19, the first interim bail was not taken care of, not even spoken out in this order. A new interim bail is granted. Furnishing a bail bond of 10,000, whereas the first order says it's a bail bond of 20,000. Now the final order has made the first interim bail absolute, which is a deadwood. It never existed after the second
But
order.
we cannot go into the merits.
Lordship.
We cannot go into the merits, only on the ground of cancellation.
Now, Lordship.
Cancellation on the ground of fraud.
Lordship, the respondent number 2 in AB 2355 contended that an agreement was entered with me, whereas in the FIR, I stated that an agreement was with my mother. We are antipodes. These are two different statements, and we at never point of time said that we had two agreements. When I get a copy of the petition, I lodge an FIR, I come to this court with an affidavit in opposition, and the bail is granted. The plea taken by the respondent is that the plea of fraud was already taken and it cannot be taken now. I replied to that, Lordship. If we peruse the final order, nowhere in the order it states that I have taken the affidavit filed by the opposition stating the fraud in the court.
So the question of fraud was not taken.
No. Secondly, Lordship, to my slightest knowledge, why this should have happened, because the matter was never kept part-heard, and we have a roster system, we have a weekly roster. So when the final order was passed, it came before the learned court for the first time. The learned court never heard it before. There are 22 orders. So it is likely that it may have been missed. Lordship, they have cited Abdul Basit judgment. I have also produced the same judgment. It says it was never allowed on the points of fraud. Abdul Basit case, what I have known, there was a crime committed, an FIR, accused were arrested. The complainant came to this court for further investigation after filing of the charge sheet. Now, when further investigation was allowed, the accused came before this court saying that further investigation has nullified the charge sheet filed earlier. So it was under that impression, a default bail under 167(2) was granted, Lordship. It is not a case that the accused in Abdul Basit's case has done some forgery and come here. Now, Lordship, they say the prolonged investigation for 7.5 years. I have presented one judgment of the Madurai bench just passed last month. Lordship, when perfunctory investigation is carried out, it takes away my right under Article 21. I am the victim, not the accused. He is enjoying the benefits of perfunctory investigation. How can he take that plea? Now, Lordship, in they have also cited that this court cannot revisit its own order. In Bilkis Bano case, Lordship, the bail was granted by the apex court. So which court we have above the apex court? The apex court cancelled it. In the Bilkis Bano judgment,
The apex court also has the plenary powers, but yes, the main law point in this petitions is that whether on the ground of misrepresentation of facts or fraud, the cancellation, the power of bail cancellation can be exercised.
Lordship, in the Bilkis Bano judgment which I have produced before this court, the 362 and the Abdul Bashid case is properly addressed. They say when you play fraud on this court, you have no remedy. Everything goes.
That we know, no?
Now, Lordship,
vitiates everything.
Now, Lordship, whether a fraud has been done or not, and whether I have got sterling quality evidence to prove that. Lordship, when I filed the opposition, it was a mere allegation and a complaint was filed, a registered FIR was there. Today, I have come to this court after a charge sheet filed and cognizance taken. A prima facie evidence case made out. Lordship, the best evidence lies in IA 1308, which I have filed before this court because all are connected matters. And it will clear out every doubt about this case. If my lords can kindly come, IA 1308, Lordship. Because when I filed a case here, the opposite party filed a case against me in Arunachal.
Connected. Okay, this we have not heard, no?
No, Lordship. I'm just, since all the cases are tagged,
referred.
Lordship. If my lords can kindly come to page 121, Lordship.
In this also you are appearing? You are appearing in this also? 1308 IA? No, I am asking him.
No, he is not appearing.
Who's the respondent here?
Actually, my lord,
You want to show me something, no?
Lordship, I just wanted to take my lords on page 121, Lordship.
21.
My lord, if Lordship permitted, that case might be fixed in another date, my lord.
Yeah.
Yes, no, we are not taking up, just pointing out a FSL report in that.
Who's Mr. Basumatari and?
Our usually appeared, my lord. He's from the Arunachal.
Yes, anyway, he wants to show something from this.
Lordship,
Yeah,
Lordship, it's a FSL report. I say the agreement.
121.
Lordship.
Okay.
Now I was arrested in an Arunachal case. I produced the documents with my mother. The FSL has come up with a report that the signature of the accused on this report and this agreement is genuine. Now, Lordship, if the agreement with my mother is found to be genuine, the agreement as alleged to be with me is false, which is attached in AB 2355. So this case is made out more than what is required.
This is what you want.
Now, Lordship, he has not challenged this FSL. Now he says FSL may have opined clearly, but there may be other circumstances. Are you playing around with this court, experimenting with lies? Is this a laboratory?
Anyway.
Lordship, one more page I would like to bring to my lord's notice, just in this, because my lords can kindly come to page 104 and thereafter page 105.
Yes.
In AB 2355, he said he paid me incurred an expenditure of 25 lakhs. Here he says I paid police 80,000 in Dibrugarh, and Lordship, the next page, the expenditure comes to 40 lakhs. Is it differing from court to court?
Anyway, going to this.
Since everything is his evidence, Lordship, this is there. Now, Lordship had asked me to come up with a judgment where bail was cancelled for fraud in court.
No, I not really.
The Lord had queried, and I have been able to get one, Naveen Singh.
No, we are also doing this. But if you find, I said that if you find.
Lordship, I could lay hands on one. I don't know the exact way of presenting my case.
Person, so I cannot.
Lordship,
Direct-
I apologize, Lordship.
No, no, no. I
Now,
cannot
Lordship, in
direct
this,
you.
Lordship, in this case, the applicant did not do the forgery. He was in bail, he was in custody. The question documents were in the custody of the court. Even then, the Supreme Court opined that fraud on court is the most serious of the matter.
It is a serious.
And he took the plea that this court has given bail under 468 and 471. The court even rejected that. He said, if you are the beneficiary of a fraud, your bail cannot be there. His bail was rejected, cancelled, and he was sent to prison.
Yeah.
Lordship, I have just placed with the other. Naveen Singh, Lordship.
Okay.
2021,
Yes.
6 SCC 191, Lordship. Lordship, I would like to place, take my lords to one more judgment, that Vikram Bakshi judgment, where this procedural review and all has been discussed in length. I will take just a few lines, Lordship, if my lords have that judgment.
You have given no, earlier?
Lordship, Vikram Bakshi.
Okay, got it.
Lordship, page 17, para 31.
Yes.
Para 31, the third line. In Greenlands Bank Supra, it was observed that review can be distinguished between procedural review and substantive review. A procedural review is inherent and implied in a court to set aside a palpably erroneous order passed under misapprehension by it. However, substantive review is when error sought to be corrected is one of law and is apparent on the face of record. Now, Lordship, I will take my lords to page 19 of the same judgment, para 34A. Here again, the court takes into account the bar under 362, having said that the following exceptional circumstances may be identified wherein a criminal court is empowered to alter a review in its own judgment or a final order under section 362 CRPC. Now, Lordship, the reasons are here. Such power is expressly conferred upon court by CRPC or any other law for the time being in force. B, the court passing such a judgment or order lacks inherent jurisdiction. Lordship, third, a fraud or collusion is being played on court to obtain such judgment. Lordship, this case, the fourth line, a mistake on the part of court caused prejudice to the party. A mistake on the part of the court. No bar. Now, my lords, where I am barred, it comes on the last paragraph, the last 4 lines. Moreover, the said power cannot be invoked as a means to circumvent the finality of a judicial process or mistakes and or errors in the decision which are attributable to the conscious omissions by the parties. Now, Lordship, if I came to know of this fraud and I kept silent, I have no recourse here coming to this court again. I never kept silent. It may have missed. So can this court say you have done fraud? My hands are tied under 362. You have the right to bail. Go and enjoy it. Now, Lordship, much time is not left. I will take my lords to three points which were raised by the other respondent. Lordship, he raised my locus. I am the informant of the case. Naveen Singh judgment says I have the locus. It was referred to by this court earlier on occasion also. Email to the registry for expeditious trial is my right. If I seek a particular bench, I may be called for bench hunting, but I never said so. The court recused itself, which had passed the order. Thereafter, I came to the registry for expeditious trial before a superior court. What wrong I have done? I am from Calcutta. I couldn't come every day. I appear through VC. The court asked me to appear in person. So where is the case? And even my lords will agree that I pressed for an early hearing and a daily hearing, which my lords allowed me. Now, Lordship, the best part which I need to reply here. I have been called an FIR activist in lines with RTI and PIL activist. Lordship, if ever I made a wrong complaint, the police is not obliged to register FIR. It is registered only when a criminal cognizable offense is made out. None of the FIR has culminated into a finding that my complaint was wrong. Each has culminated into a charge sheet and cognizance taken. They have never appeared before any court. They are under warrants everywhere. I don't find pride and joy going to the police. It's you who are habitual, ludicrous, recalcitrant offenders. How can you say I am a FI activist? If you say so, you are insulting the wisdom of this court, which has taken cognizance on every account. You should have not done the crime, and tomorrow you will say that why I did not register an FIR when you noticed the crime. You will be coming against me. Lordship, the best part I need to address, he said, silence is my constitutional right. Lordship, this court did not send you a notice or summon or invitation upon being summoned by the IO to come and take anticipatory bail. You came to this court invoking extraordinary inherent discretionary powers. Gurbaz Singh Sivia says should be used sparingly, but the court believed on your submissions in the petition which are sworn on affidavit. Sakiri Basu says the court should least interfere. Still the court interfered. And you say my side, this is not a trial. You came to this court in anticipatory bail pleading that I have submitted everything. In the first bail, the IS 665, he said I have got nothing. Second bail, you say I have one. My lawyer did not produce it before the court. In the affidavit, you say I have two. Maybe tomorrow you will say I have four. Which article of the Constitution gives you the right of silence in anticipatory bail petition, Lordship?
No, that's
Such an absurd submission in this court. Even I am not a student of law, but I will never imagine to make such a submission in this court.
anyway.
Lordship, in IS 665, the pleadings are against the accused. He himself admits that I have done fraud, suppressed the facts. In the first petition, I did not disclose. In the second, I disclosed. Now, the affidavit in opposition nullifies of both. You had two. Now, the court gave you an opportunity to come up with clean hands, show that you paid. You have the excavator's document. You had insurance over it. You couldn't come with anything. Tomorrow, every thief that is who are languishing in the jail will come up with a 10 rupee stamp paper that I bought this vehicle which has been stolen. And if this person doesn't cool his heels in the jail, it will be a bolt on everybody. You bought a capital item of 50 lakhs. You don't have any proof of even 50 paisa having been paid. And you say I am innocent. You are law-abiding citizen. You are the most law-abiding citizen.
We are not going into the merits now.
Lordship, we are within the four corners of the petition. He said that I have got everything. I paid for it. I got the original documents. Nothing he could produce, Lordship. That was the opportunity afforded to him to file an opposition affidavit. We are not into trial.
Anyway. So this will close IA 799 and
665. Lord.
My lord, both may close both.
But they are tagged together. So we have to segregate.
Both
No, Lordship, each is
799 and 665, my lord, both may be closed, both are. And already, my lord, Mr. I also spoke with Mr. Asuna, my lord. He also informed this court, want to inform this court.
But criminal petition 558 and IA 1308.
That may kept pending.
There has to be because we have not heard.
Now, Lordship, IA
segregated. This will be segregated.
Another IA
Taken
also.
out.
Now, Lordship, IA 195 is attached to IA 665, Lordship.
Yes.
Now, that has to be had with this, Lordship.
Another IA also, my lord.
195.
195, my lord. That also may dispose of.
There is no, we have not heard.
No, Lordship.
There has to be heard. Then
Lordship.
remain part heard again.
Lordship, part.
And I get the orders. You write the point. Just the point. I 799. We have completed hearing. 7, I will just cross check with both of you. IA 799 we have completed.
Got
It can be reserved for order. Then IA 665 also we have completed, we can reserve for order. Along with 665, this IA 195 is also tagged. That we have not heard. And criminal petition 558 along with IA 1308. We have not heard. 558 of 24. That means again I am saying IA 799 of 23 and IA 665 of 24 heard complete. Criminal petition 558 of 2024, IA 1308 of 2024 and IA 195 of 25 remains to be. We'll make the order like that.
Lordship. So it remains part heard, Lordship.
No, this will remain part. It will be sort of
Part heard.
My lord, may I submit one thing, my lord?
This will remain part heard.
This learned
What about 799? This will also remain. This is completed.
This is completed, 665 completed, Lordship. 195 remains to be heard because it is attached with 665, Lordship.
Yes. My lord, may I submit one thing, my lord? The learned petitioner in person relied one forensic report, my lord. That may be provided to me, my lord, helpful.
On 665.
No, some.
I will guide you properly. You can apply for certified copy. It's on the record.
No, I will.
So it will be more authenticate.
If he provide a copy, Xerox copy, it will be most
Since
easier.
it is tagged together, so can I reserve 665?
Lordship.
Can I?
My lord.
Because it's
Lordship can reserve 799 and 665, Lordship. The other three remains unheard.
Even Lordship may part out 195 also, man.
No, it's not heard at all. Not
I don't
taken.
know. You mentioned on this on the last day.
I mentioned, but not even opened up.
Then it's okay.
That's your
I'll give you the order. It's on.
My lord, item 45, 48 was submission, not it?
Yes.
8.
Just a
Sorry,
minute. Yes.
item 48 said to be provided today interim protection, but time is not there, so lordship may kindly fix on Monday.
Which one? This matter?
Item 48.
48. 48. We have done. Order sort of. Interim order was to be considered.
Considered today.
Nice.
Lordship, item number 46.
Just a minute.
In item number, Lordship, IA, Lordship, in
Yes.
present IA, Lordship, we have received the case side in respect of Dibrugarh PS case number 442/2018. Whether I should keep it as, we have to retain the CD or we have to send it?
No, don't send it back. You retain it. You know, but we'll have to work it.
Lordship,
Because 195 remains to be heard.
yes, remain to be.
That is
Whether it has to be sent back for updation or. whatever.
that I'm not sure actually. I'll have to look at
The earlier occasion, the earlier occasion, the report directed us to submit a report. And to that regard, we have received this report dated
my-
6/2/2025. So whether it will cover everything or we need a present status.
I'll have to read and check it. I have to
Lordship
check.
had to
I have
check it.
check.
So I have to keep it.
Retain it.
Lordship,
You can submit it.
Lordship, item
I'll come to you. Don't worry.
Lordship, with regard to.
I'll just come to you. No, because we'll mix up otherwise. So it's just you retain it for the time. Yeah. See, this matter, Monday could for Monday.
Lordship, Monday.
No, I'm not saying Mr. Mahmood sir's matter.
Oh.
And that was for Monday. He requested for Monday. No, what was that matter? 40, yes, 40. Fixed on Monday. And then this matter, when should we fix?
Lordship, actually.
This round, you have been here for a long time. Would you like to go back and
No,
come again?
Lordship, I will be most pleased
Because
to
tomorrow,
Lord.
next week, we have a very
I have
hectic
not
schedule.
Difficulty from next Monday. Lordship.
Like very
Because of
hectic
the medical
schedule.
grounds, I have to leave the.
Yes, yes. You will not be available. Yes.
Yeah.
I have been told. So can you work out a date according to you after you come back?
Lordship.
It has to be handled by you only.
It doesn't matter, somebody else can
Can
also
also.
handle.
No, but next week will be very hectic. I'll leave it open.
Yes.
Yes.
As a Lord.
Fresh sharing.
Because I have to take a longer.
Break.
vacations. Whether it is convenient for the other side or not like.
So if he's insistent, then fix it next week, but we'll have to adjust it. One of you have to fill in.
May I please,
Anyway.
my item 46, my lord, lordship fixed today, my lord, for consideration of bail, my lord.
New matters, okay. Item?
46, my lord. Any day, my lord, next week, my lord. Because your lordship fixed, my lord.
What is the sentence?
3 years conviction, my lord. I submitted last occasion, my lord, in my lord cases being.
Let it be immediately after reopening.
Lordship,
The first day only.
which one?
5-1.
Fine.
Item 46. List on 5. 5 or 6? 5.
Lordship, there is some urgency with regard to item number 20. It is the last item in admission. Before the learned trial court, next date is fixed on the 16th, coming Tuesday. So I can't, may pray Lordship, the matter may be taken up on Monday. There is some urgency, Lordship. Already amicus curiae has been appointed in this case. Monday, item number 20.
May it please your lordships. Lordships, item number 18 of admission column, lordship. This is a Zimma matter, lordship. For last 50 days, my vehicle has been kept in the PS, lordship. And the vehicle is not in any way connected with the LS documents, lordship.
Fix it, but
On Tuesday, maybe, lordship.
No, because 18. 18 of March.
On 17 or 18, lordship, as per convenience of this court. lordship.
18. Let it be on 18th.
18, lordship. Obliged, lordship.
Definitely, lordship. I will mention item number 19, maybe before vacation, lordship.
After vacation.
Before vacation.
Now, what is the matter?
Washing, matter.
Washing after vacation. 25 washing.
Before vacation, lordship.
Why? Because next week we are packed. Fixing will not do. Because it has to be reached. Any date is coming up. Interim date is coming up.
17.
6. See, both sides we have to be realistic. Otherwise, would not fixing is easy, but it's not reaching, causing you a problem. I understand difficult. You have a right to be listed and a right to be heard. You have to. Next.
May it please your lordship, I beg to mention item 53, which is the only matter for hearing fixed today. It's a part heard matter and.
What is this matter? Part heard? Heard by me.
I'm sorry.
Remembering. Shouldn't one. Anyway. After vacation.
Well, after Bihu, if possible, man.
After. After Bihu. You can. Would you like to suggest a date? If you want to suggest like 11.
No. After the 20. Lordship.
201.
20 Jan.
20 Jan.
I'm extremely sorry, Lordship. The 53 item number, can it be lengthy after opening?
Which one? Which one?
53. He has mentioned, I'm extremely sorry for me.
No. Just now.
Just now. Can it be after opening? Because the cancellation bail matter is there, so it will be too long. It's regarding cancellation of bail.
This one?
Yes,
Criminal
this is-
petition.
53.
Your lordship fixed it on 20th, my lord.
No, that's what I'm saying. I'm just praying for an early date. That's what I mean.
No, you just mentioned, right?
Yes. I'm sorry.
Work it out. You want it before Bihu?
Yes, before we.
If you,
It will be 7th, 8th, 7th, 8th,
and 8th, I'll be out of session.
9th, maybe. 9th?
It's up to you.
No, sir. Deeply obliged.
It's up to you.
Item 47. Item 47, lordship. Yes.
Tell me, because I have to go for reference.
Yes. Interim order may be continued, lordship. Interim order is there.
Don't worry.
Obliged.
All not rich matters, interim, don't worry about interim. That will stop your.
Lordship, I beg to mention item number 16. Kindly matter may be taken listed after vacation.
Vacation, yes. Fix a date.
Kindly date may be given, Lordship.
Well, he'll give you that date. Because I will get, otherwise I can sit, no issues.
Your Lordship, kindly give me a date on 19th January.
Which date? Which case?
16 only.